Honorable members, good morning and Happy New Year to all of you. May you have good health, most importantly for you and your families and your colleagues here in Parliament and elsewhere. And I am sure that we're going to have a really good year. Shall I say a strong year? I don't know if good is the right word, but we've got a lot of work to do this year. So Happy New Year to you. I see Honorable Dagmo in his traditional seat there at the back. And may I say the same Happy New Year to our guests from the Special Investigating Unit, and to you too. May you have a really strong year. We're not seeing each other for the first time because we had our preparatory meeting last week. It was last week, right? It was last week. So yeah, we're talking to one another. And to our colleagues here in Parliament and all our guests, Happy New Year. I actually wish we were starting this this session on a different note, but seeing that the topic is the Department of Defense and military veterans and Denel, it's Honorable Beck. It's a rather difficult time given the number of lives. I think 9 officially. But there is talk of a higher number of casualties coming in from the Democratic Republic of the Congo. And so the matters that we are going to be talking about here today are really important because in the defense environment, and I think in the police, and everybody has to pull their weight and do best to meet their constitutional mandate because lives are at risk. And I think it is true in the case of the police as well. And I think it's not the first time we've had a conversation here where we all recognized as members that the state of the Department of Defense, of the SANDF, the Navy, the Air Force, is a threat to the lives of the personnel that serve in those agencies. And so when we see something such as we see in the DRC, it's more triggering than it otherwise would be because of the matters that we're dealing with. But most importantly is to send the condolences to the families of those who have passed on while serving the peacekeeping mission in the Congo and serving South Africa, and also to wish a speedy recovery to those that have been wounded in battle, and to really pray and hope for the safety of those who continue to serve there under what it seems are really difficult circumstances for all of them. I have invited the minister members, and this was before any of this occurred. We didn't know. It was out of the session with the Auditor General in 2024 that we have invited the minister to come to the Standing Committee on Public Accounts on the 18th of February. So that meeting is scheduled for that date. I don't know how the situation in the DRC will develop, so we will have to see, but that is the date that is on our calendar as the 18th of February. That the minister will come and appear before the committee. So today, let's try and do our best to kind of focus on the specific matters at hand, knowing that the minister is coming to account to the department. Thank you very much. Honorable Kubega, welcome. Honorable Atkinson, welcome. And Honorable Beck, welcome. And all the best for the new year. It's good to see you back. Advocate Motibi, I'll hand over to you. Thank you.
No, thank you very much, Chair, Honorable Chair and Honorable members. We really appreciate the opportunity to appear at Scopa and present on the investigations that we have conducted at the Department of Finance, Department of Defense. Department of Defense.
But you are all in the wrong meeting. And my whole intro was
Apologies and apologies, Department of Defense and Department of Military Veterans and Denel. Honorable Chair, just to introduce the team, on my right is Mr. Lekgeto, who is the Chief Operating Officer, responsible for all these investigations. On my left is Ms. Zota Klesibe. She is the Acting Chief National Investigations Officer, responsible for the national investigations, all of whom are being presented today. At the back, we've got Advocate Vanara, who's the Chief Legal Counsel. And then we've got Mr. Rexon Masinga. Maybe he can just raise his hand so that the committee can see. He's the Principal Forensic Investigator. He's been leading the investigations in the Denel. And then we've got Mr. Jabu Masilela. He's the Forensic Investigator Specialist. He's also leading some of the investigations in the Department of Defense. And then there's Advocate Victoria Mdlalose. She is the Forensic Legal Specialist. She works with almost all the investigators, including all these teams here, to ensure that the legal outcomes are sound. So, Chair, with your permission, we can really now proceed. As I indicated, we are presenting in the portfolio of the Department of Defense, as the Chair has said. We are covering the proclamations R32 of 2019 as amended by Proclamation 57 of 2019. That covers investigations in Denel. And then followed by the investigations in the Department of Defense, which is R41 of 2019 and R23 of 2020. All of these investigations, as the honorable members can see, that they really date back, almost 5 years or so ago. As complex as they were, most of the, in fact, all of the focus areas that are investigated, the investigations on those focus areas have been completed. What's now happening in some instances is really to give the implicated parties the right of reply, and also just finalizing some of the referrals. But substantively, the investigations have been complete, and we will indicate as we present. Honorable Chair, based on the preparatory meeting we had, we tried, and I'm sure there will really still be an area of improvement in terms of summarizing and the details. So we will continue to do our best until we really ensure that we increase the efficiencies. So we tried today both summarizing, which is really more stats, and then going into the details. But we are of the view that we could cover both, because the slides have really been we tried to limit the number of slides without limiting the information. Right. As I indicated, the first investigation in Denel, and investigation focus areas are substantively completed, as we will indicate when we present. What is left is the maladministration and the governance and systemic investigations. Because that part, as we have indicated to the committee before, that we would like every investigation, while the focus areas of pure irregularities are completed, we also want to cover the maladministration and the governance failures of the state institution. As indicated, the next one, which is in the National Department of Defense, is also completed, but will indicate in detail in the next slides. Now, as we indicated, the next, slide number, I think slide number 5 in my presentation. These are the finalized investigations. Honorable Chair and honorable members, in respect of Proclamation R41 of 2019, it was really investigation into Microsoft licenses procured by the Department of Defense. The SIU was mandated to investigate procurement or contracting of Microsoft software licenses by the Department of Defense and military veterans, which occurred between the period 1 February 2016 and 12 July 2019. The SIUs were also required to investigate any possible unlawful or improper conduct by the employees or officials of the department or applicable service providers or any other person or entity. We investigated the procurement of Microsoft software licenses that were procured by the department. As I indicated, whilst the investigation has been completed, we have referred 2 civil litigation matters. Those involve a company referred to as EOH and a company referred to as software. The full name will come on later. And we're naming them here because clearly the civil litigation process, and in particular EOH, we've been engaging with them, and in some instances they've actually even made payments based on the acknowledgement of debt. We've instituted these civil proceedings at the Special Tribunal for the cancellation of the 2016, 17, and 18 contracts. Combined value thereof is about 467 million. The application is opposed by EOH and Department of Defense, and the matter is under case management. The other matter is also, well, the software one is also opposed by Software One, and Department of Defense. Similarly, the matter is under case management by the President of the Special Tribunal. Now, all of these matters assume that there were irregularities that were found, and now we will go into those irregularities, and at the end, Honorable Chair and honorable members, we will then present our general observations and the systemic recommendations that we have picked up. Those start from slide 46. At this stage, Honorable Chair, I'm going to hand over to my colleague, Mr. Lekgetho, to really then proceed with the outcomes of the investigations. They're going to share the investigations between himself and Mr. Sibe. Thank you.
Thanks, Advocate. Good morning, Honorable Chair. Good morning, Honorable Member, and my colleagues at the back. In terms of the outcome of the investigation, the summary of the recoveries that we have made, this relates to, the first one is the cash that we have recovered. As Advocate has indicated that EOH has made commitment to pay. So they've signed an AOD to their value of 41.6 million, and that money has been paid to date. In terms of referrals to the Department of Defense, for Proclamation R41 of 2019, for criminal referrals, we have referred 41 criminal referrals to the NPA. And in terms of disciplinary, we have referred 23. Civil litigation, those are the 2 matters that we spoke about that is currently under case management. So those are the matters that we have referred in terms of defense. Then in terms of Denel, the summary of outcome, we have achieved the following: 14 referrals that we have made to relevant prosecuting authority, including the AFU, and 2 matters we have referred for disciplinary action to Denel, and we have made recovery of 559,000. And we have instituted civil proceeding through the special tribunal for setting aside the contract valued at 229 million on the VR laser. And we have also instituted civil proceeding through the Gauteng High Court for the rescission of a default judgment, staying all any execution proceeding during which may have been issued in the action. And in terms of potential outcome, where we are currently busy with some of the loose end in finalizing the investigation, we will be instituting a civil proceeding through the special tribunal to set aside the decision or resolution and interdict the use of SAIP by the UAE government, which is valued at 320 million. And we will be making referrals to the prosecuting authority, which is 3 of them. And there's also 16 administrative action referrals to CIPC that we'll be making. And there's also 2 referrals to the Legal Practice Council that will be going. And will be issued a report on governance failure at Denel, just to cover up the issue of the governance as to exactly what happened, what led to the failure at Denel. Then in terms of Department of Defense, the Proclamation R23 of 2020, these are the matters that relates to the PPE. We have identified the following outcome. There is 33 referrals made to the relevant prosecuting authority. Those are criminal referrals. And also 11 matters refer for disciplinary action and 2 matters referred for administrative action. That is to the Competition Commission. In terms of the potential, those are the matters that we're currently finalizing. We will be instituting civil proceeding through special tribunal to set aside 5 contracts to the value of 273 million. And also we will be instituting a civil proceeding through special tribunal to freeze the pension of former SNDF officials that were found guilty through the matter under review. Also, will be making 1 referrals to SARS in respect of 5 suppliers and 135 beneficiaries, and 6 referrals for administrative action. Also, that is for the Competition Commission. Next slide, also under Department of Defense, Proclamation R23. Under Proclamation R23, there are 2 matters that we are dealing with. The first one is the one I spoke about. The other one is the interferon alpha 2B Hebron drug matters. This matter relates to the drugs which were procured by the defense during the state of disaster. On this matter, the SIU identified the following potential outcome, where we will be instituting civil proceeding through special tribunal for setting aside the contract valued at 217 million. And also will be instituting a civil proceeding through the tribunal for the recovery of an amount of approximately 33.4 million. And will also be making referrals for disciplinary action against 25 officials of the defense. And will also be making systemic improvement recommendation on systemic deficiency that we have identified. Then the last one is a proclamation R239 of 2025, which look at procurement matters. This is various matters. This matter is new. It was proclaimed last week, Friday. So we're currently on the planning phase of the investigation. Then in terms of the details of the investigation, I'll hand over to Sizora so that she can take us through the Denel. Thank you, Chair.
Thank you, Mr. Kheto. Good morning, Chairperson. Good morning, honorable members, AJU, colleagues. I'm taking the committee through the Denel investigation, and this matter was emanated from the allegations that we received way back in 2018. And then some of the allegations, they came from the results of the audit that was done at the time. And then there was a need for these matters to be referred to the special investigating unit. Then subsequently to those referrals, we then received Proclamation R32 of 2019, which was published on the 5th of July. And later this proclamation was extended to extending the scope of investigation on the 8th of November 2019. In terms of this of the proclamations, the focus areas of our investigation covered 6 key areas. When I mean 6 key areas, I don't just mean contracts, but I mean the areas of our investigation which may include a number of contracts. The first one was then the procurement of information technology security assessment services. Then the second one was the white paper, then the procurement of legal services, and then the procurement of and contracting for steel fabrication services and steel fabricated goods. That would have been a very wide scope, considering that Denel is actually dealing with the production of armored vehicles. Then the awarding of bursaries by Denel, and also then the unlawful measures or practices in relation to the misappropriation of the propriety and intellectual property rights in the Denel missiles. I will first then report on the procurement of IT assessment services. The allegations in this regard were that Denel did not follow any formal processes in terms of their procurement and SAM procedures in the conclusion of the IT assessment services. And it was further alleged that Denel failed to follow their own SAM policy. This contract, Chair, involved a company called Telspace that was appointed for the red tape penetration test. And the red tape penetration test is to check the vulnerability of the institution to hacking of their systems. So that this contractor was then appointed to deal with that. So this, the procurement process was found to be irregular in that Denel contravened Section 217 of the Constitution, the PFMA, and Denel's own policy. The advance payment of 4.6 million was paid to the service provider, which payment is against also Section 7.1 of the PFMA, read with Chapter 15 of the Treasury Regulations. We also identified and observed that State Security Agency was not involved in the process, and yet Denel is a national key point. The penetration report is still outstanding to date, Chair, and the identified potential ICT security issues were only reported to Denel by way of a PowerPoint presentation. So no report has been submitted to date. The service provider is litigating Denel for the balance, which is the 30% of the contractual amount. And I'm pleased then, Chair, to report that Denel has also lodged a counterclaim against the service provider. Denel has also raised a point in the limine on jurisdiction. And in doing so, they are relying on the arbitration clause of the contract. And we as the SIU are supporting this view. We will then apply for the joinder when the order relating to the jurisdiction has been determined by the court. Denel is currently, they've appointed the services of an IT expert to look into then the work that was done. So the quantum of the claim will then depend on the expert report commissioned by Denel in this regard. So at the time of our involvement, Chairperson, there were a number of people who were already left the employ of Denel, and some of these issues, they were dealt with by the group CEO and also then in consultation with the former board chairperson of Denel at the time. The outcomes, we are looking at then recovering, if this process goes our own way, the recovery of that 4.6 million that was paid to the service provider. And also, I'm pleased to report that their money has been kept. The service provider reported to us that he has not used a cent out of the money that was paid by Denel. So there are no criminal referrals, Chairperson. We were constrained in this instance by the PFMA limitations, because in terms of the PFMA, only the accounting authority will be found in the wrong in terms of this, and yet the accounting authority in this instance was not even aware of this transaction. Then the disciplinary referral, we could not, because we could not refer at the time because the implicated officials all left the employ of Denel. The next one was the development of the white paper. The allegations were that Denel did not follow the formal procurement processes in appointing an entity to develop a white paper. At the time, the documents were missing. It was only through our interaction with the people who were involved, who had left Denel, that we learned that some of the documents were actually handed to them through then the discovery process of the CCMA processes. And then we, through those documents, we realized that actually Denel did follow a process when appointing an entity for the development of white paper. Just to give a background, Denel experienced severe cash flow problems and was very struggling to raise funds to pay their salaries. So then they approached AMSCO to relax some of the non-compliance guarantees, and AMSCO approved a limited period part relief on the issued guarantees, which freed up their credit banking facilities to allow Denel to settle some December salaries. This is now 2015, Chairperson. There was an urgent need for the, 2016, Chair. There was an urgent need for the development of white paper for a funding model for Denel. Denel sought an approval for a deviation from the supply chain executive for the same white paper. This approval was granted on the 13th of September 2017.
Sorry, may I ask, so the supply chain chief executive were at AMSCO?
No, at Denel. Within the process, the SCM processes within Denel detected that they had to seek an approval from the supply chain executive within Denel now for this new deviation.
So the official who were responsible for this white paper asked the supply chief executive for
Deviation certificate.
Okay, later on, just fix that, because when you say deny, it's the whole institution, so it can't then ask an official.
Internal, all right. Oh, thank you, I'll fix that.
AMSCO is the procurement arm of
Defense, yes.
I got a bit confused.
Oh, sorry, Chair, sorry, apologies for that. The approval was then granted on 13 September 2017, and then from this process, 3 quotations were then sourced, and then the service provider was appointed based on then the price. Then we found no irregularities in terms of this contract and the process that led to the appointment of the company. The next one would be the legal services. In particular, Chairperson, it's not all legal services. The complaint related to the appointment of a certain legal service provider, a firm of attorneys that was appointed to render legal services to Denel without following any proper procurement processes. The firm was not even listed on the Denel's database of legal services, and also was also not part of the existing panel. So this service provider was just handpicked from somewhere to then become one of then the service providers at the time. The value of the contracts awarded to, or work that was awarded to this legal firm was about 10 million rand. The investigation is also finalized here, Chairperson. Our findings are that then there was an irregular procurement process. We could confirm that this entity was not part of the existing legal panel, and no contractual agreement was signed between Denel and this entity. Then the former GCEO and the chairperson, they managed and directed the project, and Denel's legal department was not even involved in the process. There is no record or instruction files kept by the firm. In some of the invoices submitted by the firm, there were no supporting documents and no statement of accounts attached. The investigation further established that in one invoice, the one invoice that was for legal services was not involving Denel, but it was a case between Law Society and the former chairperson of Denel, but Denel paid for this invoice. The investigation also identified misrepresentation and of fraud in that a fraudulent invoice to the value of 65,000 rand was issued to Denel by the firm, and it was paid. And it was alleged that the claim was on behalf of a counsel team without his knowledge. We have interviewed the advocate, and he has confirmed that he has never claimed this amount. Then there was also fraudulent double billing and possible embezzlement of cash, in that some of the claims that were facilitated by this firm, the payments were made by the entities, but they were never paid back to Denel. And the attorney and the former board chair were provided with an opportunity to respond to our findings, and that is like the right of reply. And we received no responses from the former board chair, but the attorney did respond, and based on the responses that were provided by the attorney, we will continue with our referrals, Chair, because there was no credible response that was afforded. In terms of then the outcomes, Chairperson, so we are in the process of referring the account to Taxing Committee of the Legal Practice Council for the review of the 10 million rand services. We're also referring the matter to CLU, but this one will do it through a letter of demand because of then the quantum. Then the criminal referrals, Chair, we are referring to 3 criminal referrals in this instance for the theft of trust funds, as well as then the fraudulent invoices that were submitted to Denel. Then the disciplinary referrals, we have already indicated in our potential outcomes that we are referring disciplinary matters to the Legal Practice Council on the conduct of then the firm, as well as then the former board chair, because he's a legal practitioner. Then the project Hofheister contract, Chairperson, this is the first time, Chair, that we are reporting on this in this committee. This contract was referred as part of then the mandate that we have to the SIU around 2022. This is an old contract that was signed between Armscor and Denel. It's a 2007 contract where Armscor board approved then the placement of contract 1161 to the value of 8.3 billion rand to Denel. This is now DLS, Denel Land System, for this project. Project Hofheister was for the design, the development, and then the manufacture and deliver of 264 different variants of vehicles, armored vehicles, to Armscor in the period of 140 months, which was 10 years. This was approved for the acquisition of the new generation infantry combat vehicles vehicles product system, which is then the NGICVPS. The original requirements detailed in the purchase order, which is listed there, Chair, consisted 5 current combat variants: the section variant, the combat variant, the motor variant, the fire support variant, and the missile variant. These were the 5 variants that were part of the contract. Each combat variant included logistics, ammunition, and training simulation. SANDF later amended their requirements to include additional new variants, and the new order was then issued to accommodate SANDF request. So then there was like further amendments to the contracts. In terms of this contract, Armscor has already paid in excess of 8.1 billion to Denel, as well as then the other service providers, especially those that are owning the IP. And to date, Chair, only 21 vehicles were built and completed in terms of the stages of the contract. Armscor has not yet taken delivery of these 21 vehicles in terms of the contract terms. Most of the work is still work in progress. In this regard, Chair, I will just pause a little bit. In this regard, Chair, we have observed that Denel has procured most of the stock, and then they're keeping the stock on site. However, some of the stock that they've procured at the time is currently obsolete. You know, they procured some of the items like, you know, the tires, the batteries, long time ago, and then these now are currently obsolete stock. So some of the items, they are still there, but obviously we are still trying to verify the insurance issues around these items. Who is responsible for then for the, you know, for you know, have they been paying insurance? Have they insured these items? If not, what were the reasons? Those are some of the issues that we are following up in terms of our remedial action. So going back then, Chairperson, some of the funds that were paid and allocated to the project were utilized by Denel for non-project related matters. And this will include the acquisition of the BAE British, the BAE Systems, which is Land Systems South Africa, salaries and other unrelated operational expenditure. For the implementation of the project, DLS also subcontracted some of the work to 30 entities that we have now identified, including VR Laser. And in doing so, they failed to follow any procurement prescripts in appointing these companies. Unfortunately, Chairperson, most of the documents relating to these transactions were destroyed. And we've interviewed Denel in terms of this, and they indicated that a junior official was actually disciplined for this act. As a result of various decisions taken at the board and executive level, DLS was unable to fulfill its contractual obligations in relation to the Hufeista contract. We have now finalized investigation. The only outstanding issue is then to get an expert to give us then the estimated value for what is left in the stores of Denel, and also then to verify then the insurances in terms of the items that were procured. And currently, Chairperson, we are following then the audi alteram partem rule that is giving then those that were involved, including the board members, the right of reply before we proceed with our referrals. The matter, Chair, will be then referred to a civil litigation for their assessment, and then they will advise us, you know, how to proceed. The former board members we have been served, Chairperson, will be served with the right of reply based on then the findings of the SIU, and our intention is to refer criminal referrals in terms of this, especially when they locked, especially Section 80, is it 82 of the PFMA, where then they actually locked the institution into future financial obligations with regards to then that procurement, the acquisition of then BAE systems. The administrative action against the accounting authority in terms of then the Companies Act will follow, Chairperson. That is, we intend approaching CIPC for them to be, for the board of directors to be declared delinquent. Then, as part of then, I'm on focus area 5 now. As part of then the Hoofheister contract, now we are focusing on the HALS contract, which is the contract that was awarded to VR Laser at the time. Chairperson, VR Laser was awarded a contract for the HALS contract, which was the platform for then these vehicles. And also, the allegations were that there were 2 memorandum of agreements that were signed by Denel with the service provider, which is VR Laser in this instance, for all steel fabricated goods to be procured from VR Laser. So our progress and findings, Chair, this matter has been finalized, complete, and we also referred to civil litigation. Our findings are that during 2014 November, the former Denel CEO appointed VR Laser for the manufacturing of hulls for different variants of the Hoofheister vehicles, despite having a strategic partner by the name of LMT. VR Laser was then appointed to manufacture these hulls, yet LMT was actually acquired as an entity, as a strategic partner for the manufacturing of the Hoofheister vehicles. Maybe take the committee back, Chair. 2007, Denel was awarded the contract. And in 2012, there was a business case presented that LMT had to be acquired as a subsidiary to assist Denel as a strategic partner for these vehicles. However, unfortunately, then at the time of then the procurement, LMT was then sidelined. The SCM processes were flouted to favor VR Laser, and it had not, had it not been the manipulation of the scores, LMT would have scored the highest points in the procurement process. So during 2015, 2 memorandum of agreements were also concluded, appointing the same service provider as a single source supplier for DLS and DVS. DLS is Denel Land System, and DVS is Denel Vehicle Systems, for all steel fabrication and steel fabricated goods for a period of 10 years. My apologies, Chair, I've got 0 years. For a period of 10 years. These contracts were rate-based contracts with no budget limit, and this process was found to be irregular. So these were open-ended contracts with no value attached to it. The first MOA was signed by the CEO of DLS on approval from the former GCEO. A deviation was later sought and approved by the then acting GCEO, even though then the group supply chain executive had declined the recommendation of this DLS ExCo to appoint this service provider. The second memorandum of agreement was approved by the former acting group chief executive officer. All processes to appoint this service provider on all 3 contracts were irregular, and the adjudication scores for the HALS contract were manipulated to favor the service provider. A service provider is currently, which is VR Laser, is under business rescue. However, this company is litigating Denel on a number of instances, and they have obtained default and execution judgments against Denel as a result of breach of contracts and unpaid debts. The SIU has instituted the civil proceedings, including but not limited to the rescission of the 2 judgments against Denel, these default judgments against Denel, and to further make application before special tribunal to set aside all the irregular and invalid contracts that were entered into between VR Laser and Denel. On the HALS contract, the SIU is applying for a date of hearing in an unopposed motion, and the respondent in this matter failed to file an answering affidavit. So in terms of the outcomes, Chair, so we have instituted these 2 proceedings, legal proceedings at the Special Tribunal and Gauteng High Court. We have referred evidence pointing to the commission of criminal offense against 7 former members of Denel Group and also DLS to the NPA. And in terms of then the disciplinary referrals, we have observed that all those implicated, they've left the employ of Denel except for 1. Another official was reported to be working for another SOE, and evidence pointing to misconduct was referred to this institution. The 2 officials were given the right of reply, and then the 2 disciplinary referrals were referred to then SAA and Denel and to the board of Denel. However, at this stage, as of this date, there hasn't been any report from the 2 institutions on the outcome. Then I move to then the chart contract. Chairperson, this is these were the allegations that were received that Denel Land System, a division of Denel, received a purchase order around June 2015 from the Chadian government for the manufacturing and delivery of 12 Casper vehicles, the NG 2000 Series B model 4x4s. The contract did not materialize in 2015 due to financial constraints on the part of the Chadian government. Around mid-2016, the Chad government approached Denel for the revival of the contract, and around late 2017, an agreement was reached for the manufacturing and delivery of 40, no longer 12, 40 Casper vehicles. The contract value was $18 million, in which Chad paid 7.2 million which was a 40% advance payment to Denel. It is further alleged that Denel procured 3 service providers under this contract to the value of 38 million rand, approximately $2.6 million of the 7.2 million paid by the Chad, in which there was little or no performance on the part of the service provider, and the appointments were alleged to be irregular. Denel is alleged to have procured the following service providers: then the technical advisor to facilitate the negotiations between Denel and the Chad, and they were paid 9.7. And then another service provider was then appointed for then the provision of the Sinod trucks, the Sinod truck train chases. These were donor trucks from China, and they were paid 13.8 million rand. And then VR Laser was also appointed by Denel, and they were paid 15 million rand in terms of this. The total amount spent by Denel is 38.6 million out of the payments that were made by the Chad government. In terms of then the status, we have 3 contracts. The first one was VR Laser. There was no performance on the contracts in terms of then the VR Laser matter, because VR Laser, before they could even initiate any work, they were appointed by Denel on the belief that VR Laser owned the IP for the Casper vehicles. So VR Laser, what they did, they demanded a payment of the outstanding invoices for the contracts that they had with DLS, and then DLS settled an amount of 15 million from the chart funds. After the payment was made, the service provider failed to render the services, and at least 15 million rand of the chart funds were then was used to settle the outstanding debt against VR Laser. Then the other one, chairperson, is then the appointment of the technical advisor. A technical advisor was appointed by Denel, and they signed a contract for the child contract. The appointment of the TA is in accordance with the Denel policy. There is a policy on the appointment of technical advisors when contracting with foreign countries. However, in terms of this contract, Chair, the appointment was found to be irregular and unlawful in that they did not follow their own policy in appointing the technical advisor, and the former GCO did not consult with the relevant departments when appointing the TA. The payment of 9.7 was made, and it's regarded as fruitless and wasteful and irregular expenditure because there is no performance on the part of then the service provider, which is the chart contract. Then there's the chases that were procured on the chart money from an entity called ENNE7. They entered into this contract with a service provider for the delivery of these donor vehicles from Chinese company called Sinotruck China. These donor vehicles were going to be used as platforms for the armored vehicles requested by the Chadians. The SIU found that the appointment of this company was irregular because the submission for deviation was based on misrepresentation. The company was paid 13.8 million rand in advance based on the purchase order, which was generated from a non-responsive RFQ. It must be noted that no contract existed between Denel and this service provider when payment was made. One Sinotruck was delivered to Denel, and the rest of the trucks were delivered towards the end of 2023, which is last year, Chair. And this was at the instance of the SIU. After we've interviewed the owner of Sinotruck, the director, then he decided to deliver a rusted truck with no value to Denel. Denel was advised not to take delivery of these trucks based on their condition, one being the left-hand drive trucks when the contract with the Chadians had already lapsed and expired. We are in the process of referring in respect of this service provider, the balance of the amount, Chairperson, but we are still locked in discussions with the Denel because they accepted delivery of these rusted trucks, which they did last year after we have advised them of our investigation. The amount is considered to be 12.7 million, which is the balance between the amount, the trucks that were not delivered and then the one that was delivered. We have found evidence pointing to criminality against 7 entities and individuals, and our forensic lawyer is currently reviewing this. In terms of then the disciplinary referrals, we've got about few, I think there are 2 members who are still in the employ of Denel, and this matter is still under review by our forensic lawyers. The presentation. Take it as read.
Can I ask that you summarize each page so that we can questions, and also if there are any other presenters, just do that. So summarize the page because you were kind enough to send us the presentation.
Thank you, Chairperson. Thank you. In terms of the pilot license bursaries, Chair, the investigation is also complete. We have recovered in terms of one matter, an AOD to the amount of 559. The other one, we have filed papers for default judgment at the special tribunal for an amount of 234. These were the amounts that were paid by Denel on behalf of 2 students who failed their obligation, who failed in terms of their obligations with Denel, even though the process was irregular. But the students were no fault. Those that, the one that succeeded, Chair, we found no fault, in getting the repayment from him. SAPS is already investigating the matter, and then the matters, they are currently precluded from sharing then the progress with us. We have, in terms of then the disciplinary referrals, there are 9 from our side. We are advised by Denel that they instituted some disciplinaries at the time. Then the alleged misappropriation of IP, I will start with P2 and P3. This resulted, Chair, from then the agreement between Denel and the UAE government, an entity style Tawazun, where Denel had to develop 2 missiles, and then where both parties agreed that the foreground will then be transferred to Tawazun Dynamics. Tawazun Dynamics being then the entity that the entity formed in terms of the partnership agreement. Unfortunately, Chair, in terms of this matter, Denel ended up losing the IP to the foreign entity called Tawazun as a result of then the resolution that was then signed by the shareholders of the entities, and yet the shareholder representative of the South African government did not get then the authorization from our government. So the matter is currently with our CLU, which is the Civil Litigation Unit, and we are exploring then the legal remedies to recover and interdict the use of our IP in the value of 328 million. There are also other entities, Chair, outside then the government space who have approached SIU because they were also defrauded by the same entities, and we are also in discussion with those entities, Chairperson. We have referred evidence pointing to the criminal conduct against 7 individuals to the NPA. Sorry, apologies to say it's under review. We have already referred these ones, and Denel instituted DC against 1 official, and this person was later dismissed. And then we've got RG35 IP. This IP, Chairperson, was the IP that was acquired by Denel as a result of the acquisition of the BAE systems. And unfortunately, this IP, immediately after the acquisition, then there was a contract that was signed by one of the officials of DVS, with an entity called NIMA, situated also within that UAE entities, government entities, and this official was not authorized to sign this contract, and we are looking at setting aside that contract. Fortunately, the IP is still with Denel, but this entity is currently considering litigating Denel for this IP, and we are saying the contract is actually irregular on those bases. In terms of then the other IP, it would have been the Saudi, the semi-government. Allegations were made here, Chair, but unfortunately, in terms of our findings, we could identify that staff was then sent to the semi-representatives, but it was not transmitted via any electronic systems. It was hand-delivered but unfortunately, we don't know what was then hand-delivered to them. And in terms of what we could find, it's only one confidential document that was shared with the SEMI. That's all we could find. Hence, we have no legal recourse in terms of that one. Then in terms of then, these are just the summary of our outcomes, which we have already spoken to Chairperson. I will then, slide number 28, we are also conducting a governance review, as the head has already indicated. And then we are looking at the shortcomings in the process of approvals, management, and expenditure related to the following projects, which is then Denel Asia, the acquisition of BAE systems and the funding related to the acquisition, the relationship between Denel and its subsidiary, which is LMT, as well as other key decisions affecting Denel. How FEL has contributed to the current position and make systemic recommendations. Chairperson, I'll pause here and allow Mr. Lekgetho to continue.
Chair, just a brief comment, and I will not repeat what my colleague has said. In instances where Denel has lost the intellectual property to UAE, well, like any other findings that we have made, it really presents a very serious scenario, and I've really instructed the legal team that this should be a test case where we follow through on assets that have been lost outside the country. There are various processes that are underway, and I'm sure I'm going to ask Advocate Vanara to come in just to really appraise the committee that we're taking this very serious, because although the individuals that were involved, we've referred criminal actions and so on, but some of those who were involved, Chair, have also, but we did indicate in the prison, they've joined the companies. So the extent of the plan, this was planned. They took the IP with all these companies from the UAE, and then when the IP was taken out, they also, because of this corrupt plan, they also left Denel and they went to join the company that's out. So the legal process should essentially include our quest to recover our IP and the monies lost, and also these fugitives that have joined Denel, the UAE companies, and we know we've got examples of cases where getting fugitives from outside of the country becomes very difficult, but we will not relent simply because of that. We will really pursue them based on the legal processes. Before Mr. Lekgetho comes in, Advocate Vanara, do you really want to appraise the committee of the legal process?
No, thanks, HIU. Good morning, Chair and honourable members. Yeah, this is really a sad state of affairs, but that presents complex legal challenges, because the scheme was executed through agreements that indicate that the disputes will be resolved through laws of a foreign jurisdiction. You need to go to a foreign court to have this issue resolved. We have our laws internally that hamstring us to act within the country and not extraterritorially. So we are looking at, together with our legal team, at various possible options. The one that seems more likely is perhaps through the arbitration proceedings and the ceding of rights that will enable us to take part in these proceedings. It's not a definitive answer, as I said. We are still exploring different possibilities in a complex, I must say, in a complex legal matter. Thanks.
Thank you, Advocate. As we will come to the systemic issues, really what concerns all of us, and this is something that would probably have to occupy us in terms of how do we really improve processes in state-owned entities and across the board, such that there are checks and balances to avoid instances of this nature happening. Because these are high value contracts, high value intellectual properties, the loss of which puts the country at a serious disrepute, disrepute. But we will do our best in terms of follow through, just so that we can really produce. Over and above the national laws, there are instances presented by the United Nations Convention Against Corruption, and this is the time where we have to test all those instruments. Direct litigation in foreign jurisdictions, those are matters that I would like our lawyers to really sort of be legally innovative here, and not really be narrow in terms of looking at legal affairs. But we will report to the committee as we go along. Thank you very much.
Thanks, Advocate Matibi. In fact, I want to suggest that we just allow the committee members to just interact with you just on Denel, because, you know, as we've said before, it starts with these kind of things, and then 10 years later, people die because things that should have been done 10 years ago were not done. So can I just ask the members? So what we'll do is we'll give each member a chance to ask questions and get an answer immediately. That will also help the members decide whether they still want to, you know, to ask a follow-up question or not. We can make comments, but no long speeches, members, please, so that we can work through our tie. I want to make sure that we finish exactly on time in these meetings, and we've got until 2 o'clock to be done today. 3 entities that we have to work through. After this round of questions, we will take a break and then come back and continue, if that is okay with you, Advocate Matibi. Honourable Member, I will start with you.
Thank you very much, Chair, and good morning once again to all the colleagues and Team SIU, led by the Advocate. Now, I'm going to have a question that is more of a blanket approach. Firstly, is on the details of where the department says it has embarked on disciplinary hearings, and you say, therefore, you are not continuing with referrals on that. In that case, can we then get the details of those disciplinary hearings? If you were satisfied with how they were treated and they are befitting of the crimes, or rather the acts committed, because I'm afraid they are going to do this. Once there's an investigation, then they do disciplinary hearing, gives warnings, and then the people get off from any other thing. And then on the R421, in terms of the criminal cases, also we don't know when you made the referral, how far it is, if those details, we can have them. Because we also don't want, Chair just made a reference to 10 years later. So if it's this long, how far are those criminal cases? If our problem is with the NPA or is it with SAPS, where are we lacking or where's the delay? Then on the procurement of the white paper, as much as this will go to the department as well. But then there is a reference that says no processes were followed properly. I want to understand, were you just investigating the process, or were you investigating a corrupt act where money was paid, we didn't get the service? Because I also have a difficulty on why would an entity like Denel, which should be having a lot of legal minds within the entity, want to outsource people to develop a white paper? It doesn't make sense to me. Why would, maybe if it's water, we can say they were looking for it, but at Denel, the expectation is that there is a legal background of many people that are on the officials, executive, or whatsoever. So was there a necessity for this legal? Because that story of they wanted to deviate for funding system that is going to curb the problem. Cash flow, they saw what was happening with the cash flow. They knew what was happening with their receivables. A year or two, you know that in 2 years, I'm not going to be able to pay. So this one for me, Siswam, I don't understand. When you say you found the process was fine, but was the payment befitting? What was happening exactly? Did we actually get the white paper? By the way, did it go to the Bill of Parliament? And what did it end up producing? Because if the white paper was developed, then where did it go to? Did it change the situation? Because as far as we know, Denel is still in the same state. And then in terms of the awarding of the pilot licenses as well, the disciplinary hearings, I've asked that one. The one that left the entity, because the disciplinary hearing was done, and then the other one left the entity. They left the entity to where? Are they not within the system? If they are within the system, they are easy to be caught. But my interest also is how far is a criminal case, if there was any criminal case in this regard. I think that's it, Chair. Thank you.
Thanks, Honorable Member. SIU team, you can respond.
Okay. Thanks, Chairperson. I think on the disciplinaries, in reference to the disciplinaries for Denel, these disciplinaries were instituted, some before we even got involved. And what happened is that Denel people then started to resign, and Denel then accepted their resignation. So in essence, they were not disciplined because they were allowed to resign in the midst of the processes. So in other instances, like for instance, the CFO, former CFO, then I think he took Denel to CCMA, and then I think at that stage, then he got an award, and there was a settlement. So Denel at that stage, they were settling most of their matters through settlement agreements. So at the point where we got our investigation, our proclamation, most of the people were already out of the system. And we have tracked and traced some, and those that are still working for government, we were able to identify and make referrals against them.
Just the last one, the one of the single source and the deviation sought for the senior executive of supply chain, what is the input of Treasury there? Because they are the ultimate arbiter when it comes to authorization and permission and such things. So what is the input of National Treasury in the single source?
Okay, is that then the single source for VR laser, or is it the single source for white paper?
House, contract, and other contract.
Okay, no, I think Treasury, in terms of those memorandum of agreements, they are in agreement with the SIU. Hence, then we are in court. We are litigating against then the entities on that one. Those are the VR laser contracts where they were appointed as single source suppliers.
Now, I think the question is a different one, which is when you need a deviation, you need the permission of National Treasury. I think that's the question. So what was National Treasury's view? Did they agree to the deviation or, yeah?
Okay, in terms of then the VR laser, the single source one, National Treasury was never approached. Then on the white paper, the deviation, the SCM policy of Denel, in terms of the value of the contract, it was in terms of the delegation. The executive supply chain executive manager had the delegation to approve those 3 quotations on the white paper. The HALS one, National Treasury was never approached. There was not even a deviation process. It was just something that was done internally within Denel. They signed the contract and then later on tried to formalize it through a deviation after then they've already implemented the contract. Chair.
Oh, sorry, yeah, go ahead.
Then, Chair, we will be able to, on the R41, may I propose that we submit another supplementary report with the dates of the referrals on those matters, the matters that we referred to the NPA. And then on the white paper, as already alluded, Chair, the SCM policy that within Denel allowed then the executive manager to approve deviation to a certain amount, and then they approved. And then in terms of the white paper, that the report that was submitted to Denel, they were able to unlock funds. As I think it was just a percentage, not. I don't think the white paper was like that one of. It was not. They were not looking for material like substantial funds. They were looking for to unlock funds to pay salaries, because at that stage they didn't even have money to pay salaries. So then they approached PIC, and then in terms of that report, then they were able to unlock funds. That means they were able to then get a loan from PIC.
Okay, so let me just make sure that we're dealing with the question. So I think Honourable Mendes' comment was that, and correct me, Honourable Mendes, if I'm wrong, that Denel should have capacity internally to produce a white paper. And I think the question was, why? Are you able to, have you got any insight? If not, it's okay. All I notice is that having commissioned research papers before in my life, that is the most lucrative I have ever seen. and they involved way more work. 9 million is a lot. 1.5 million, 2 million, sure, but 9 is a lot. But that was a question.
Okay, no, Chairperson, I don't know why they decided on appointing a service provider for this service.
Yeah, this is why this one is very weird to say, as SIU you say, no, there was no problem, because I don't understand whether the commissioning of this particular investigation was based on just the SCM processes, or was it also based on the value for money of this? Because as the chair is saying, this is a lot of money to just produce a white paper. We are members of parliament, we do private member bills. I can write my own. My researchers and the legal people that we work with are there to polish, because initially you know what you are looking for, but you are only looking for the legal jargon and all of those things. But to say you outsourced for that amount to produce, and the worst part is you just want to unlock for 2 years. It's not even going to long term where the minister then is going to table it and then develop a bill and then develop an act which ultimately is going to assist the department in unlocking more funds. Meaning which, even if we want to now argue that the department must get more money, if they do not have capacity to do such simple things, what's the point of us unlocking funds to give to them when they can't work around the entire system? So that's what I don't understand. SIU, please help us. Was it necessary, according to you? As much as the policy was done is fine, but the necessity of this wasn't supposed to have been done by someone in the department. If there was no one, was the amount befitting of the product? Thank you.
So can I intervene in this way? So I've asked the committee secretary actually to note this for an additional letter to the minister following from this, because I think that this question needs specific answering. I think what I'd like you to answer now out of this interaction is just so there's a couple of things. One, you don't need a white paper to deal with cash flow, first of all, or even like the funding problem. You can do a proposal to Treasury and to Cabinet, and so it doesn't need a white paper. So just in your assessment, the process that was chosen here and therefore the amount paid, have you been able to apply yourselves to that kind of question as to, did they need to do it this way? What was delivered worth the money?
Chair, before she comes in, the usual or normal approach really would be that we look firstly at what the allegations were. And it would appear here that the allegations from those who reported to us was that no formal procurement process was followed. And the team would probably have taken the cue from there, what requires to be investigated. But it still is our duty, of course, that as we always do, whether there was value for money, right? And from what Honorable Mente is saying, that you know, the rationale for Denel appointing the service provider, and my colleague can probably indicate if the team went to that extent. If not, then as we always say, you know, the proclamation is still there. I would really implore, and as the letter goes to the minister, we can also go back and really relook on this aspect. Really relook on this aspect, and then present to the committee based on the questions that Honorable Mente is saying. Looking at the rationale, value for money, and why is it that they went, you know, the white paper route? Is there something that's done in this industry, or, you know, yeah.
All right, thank you very much. Can we move on from Honorable Mente? So can I just ask, who wants to ask a question, actually, because I need to manage the time as well. Who wants to ask a question on this one? So I've got 3 hands. Honorable Neil May, Honorable Nontenja, and Honorable Pila. Okay, so you Haneli said you comrades on this one specifically, yes, because I just want to manage time and when we go on break and that kind of thing. So I nearly said you comrades. I mean you Honorable, yeah, I'm still on holiday. So are you have a question? Okay, so if we can just focus on questions, please, just ask a question so that they can, we're taking extensive notes here so that the minister, actually when she comes here, she responds specifically to our questions that we have for her, rather than her doing a long presentation. She'll make an opening statement and then go straight to questions that we would have sent to her in advance, and all the questions also we'll share with the committee members ahead of time so that you can add your own. Thank you. Honorable Maduna.
Good morning, Chair. Members, SIU, umuntu uyabulisa kunyaka omusha no sihlalo angizumoshi angizuchitha isikhathi cha ngifuna ukuchecka la sihlalo I-value yale white paper ukuthi develop ngicanga ukuthi bathe 9 million ne so ngifuna ukuchecka according to their policy they require 3 quotation for that threshold of 9 million. I just want to check, was it in line with what their policy in house that they have? No.
Thank you. I think we've had the question. Was it within? Okay.
Okay, thank you, Chair. Let me first respond to the initial questions. There was a business case that was submitted by the former CFO to the executive. Most of their money, Denel funds, was locked in those guarantees. Hence, then they were approaching AMSCO to unlock the guarantees on some of the matters. So then AMSCO released some of the funds, but the funds that were released by AMSCO, they were not substantial to carry the business forward. So he then submitted a business case to look for an entity that will then give them let's call it a white paper for them to get, it was more like the funding mode, where to get funds. So, and the contract then was based on a fee, it was a contingency fee-based contract. So they were going to be paid either 3% of the funds that were unlocked, but it was based on a contingency fee. Hence, then we looked at then the contract and then the fee that was raised. It was the money that was paid. It was in line with then the fee, the contingent fee percentage that was agreed upon. And then in terms of then the deviation certificate, Denel, because it's more like it's because of the quantum of the contracts that they get to be involved in. They, as you know, they only go to Treasury at the time on any amount above. You know, there would still be internally approvals up until 20 million by the divisional executive, and then 50 million by the group, and then anything above that then will go to National Treasury. Thanks, Chairperson.
All right, thank you very much. Honorable Pila, your hand is up, right?
Thank you so much, Chairperson. I think I'm covered by what she has responded to. Thank you.
Thank you so much. Honorable Neil May, are you also covered? Thank you. Honorable Nontenja.
Thank you, Chair. Good morning to everyone. Chair, mine is to say, don't they think the time that they take to investigate, which is at this point of time we're talking about 5 years, impacts on the whole outcome of these cases? For instance, we hear of disciplinary actions that people leave before they could go for disciplinary actions. And isn't that the result of the dragging of the cases by the SIU? And when the person fails to appear before the disciplinary, do they lay criminal charges or civil cases against those people? Does that happen? And also, the time frame, it doesn't impact on the fact that you might be able to freeze the officials' pension funds. When it's taken 5 years, that person must have collected the pension fund already. Does it still allow you to do anything, or the dragging of the time impacts negatively on the cases? Thank you.
Thank you very much. Please go ahead.
Thank you, Chairperson. Unfortunately, Chair, with regards to Denel, when we received our proclamation, most of the members had already left. It was a time where Denel was facing liquidity issues. It was the time when Denel was faced with all those media issues around the state capture, yes. So no, I'm just saying it was at the time when Denel was faced with all those issues when we got involved, and most of the members had already left. The disciplinaries that were embarked upon by Denel were dealt with in 2018. That was way before we even got our proclamation. And then some of the delays, Chair, are actually caused by then the non-availability of documents, some of which we were able to actually get from the same suspects that we are investigating through the right of reply. Because when they reply, then they start providing us with some documentation that are not within the Denel, because there was no handover process that was done when people left Denel. It was just like a situation where people left, some left with some of the documents. Thank you, Chairperson.
Yeah. In Xhosa, there's something called inzomi, which means like a fable. Honorable Beasley.
Thanks, Chair. So just a comment and also a bit of a question is in the last couple of years, you know, Denel's got 9 billion in bailouts, and it's quite clear that it's a sieve of corruption. And it's unbelievable that Parliament still gives more money bailouts to win it. And you just wonder, I think as Praveen Gordon said, follow the dots. And I think Parliament should be held criminally liable for giving money in such dire circumstances. I mean, how can Parliament approve money when it's a sieve of corruption? And I'd like to see people who voted against that bailout and those who actually approved it. And then in terms of disciplinary action against people that have left, I think we have touched on it, but is it not possible to get a register going that stops them from working in the whole state government entities? Because they leave one place, they go to another place. So if there's a disciplinary action against them, can they not be listed somewhere? And then have any of these companies been listed on the National Treasury database? And I probably think the answer is probably no. And I think it's a massive deterrent against companies, because once they get listed on that, they can't deal with the state. And then I think the stealing of the IP, it's a massive story, and it reads like a James Bond novel in a way. It's you know, our IP of our country is being stolen underneath our, and it's going to be very difficult to get it back. But I think in the letter to the minister, we need to make it clear that our IP needs, we can't sell that. I mean, we're giving it away. And then in terms of the board of directors of Denel, is it not possible to lay charges against him in terms of gross negligence and derelict of duties? They've got a fiduciary responsibility to protect the company, and if they've been derelict in their duties, you know, one would imagine, I mean, you see what's happening with Tongaat and Steinhoff, and, you know, is it not possible to hold state companies to a similar accountability? Thank you.
Thank you, Honorable Atkinson. I see your hand high up.
Yeah. Thank you very much, Chair. And I'd like to take this on, you know, in line with questions that have been asked by Honourable Mente and comments that have been made. Part of our problem here is that we're trying to be rational. We try and rationally to work out why people made the decisions that they did.
Sorry, Honorable Atkinson. So we're doing that thing of letting the presenters answer the specific question,
Yeah.
So that we can close that loop.
Right.
Are you asking your own questions? Because I was moving on to Honorable so the SIU is supposed to answer, then we go to Honorable Burke, and then we come to you.
Yeah, all right. Okay.
Is that fine?
That's fine.
Okay.
Yeah.
We're doing well so far. We're going to complete just now. The questions and answers are crisp.
Thank you.
You don't have to answer the policy questions. I will deal with those.
Thank you so much, Chair. Chairperson, as we will then be reporting under general observation, some of the issues will be dealt with there based on our observation as the SIU. In terms of then the blacklisting of service providers, we do make referrals for those ones, and in these instances, we work with some of the in terms of our referrals, we work with the police, because we have referred in most instances some criminal referrals against all the companies where we found evidence of criminality. In terms of then the accounting authority, the criminal referrals against the accounting authority, we've already, hence I was indicating, Chairperson, that we are in the process of then approaching them for their right of replies in most of the decisions that I've made, I think dating back from 2014. Thank you, Chairperson.
Thank you, Honorable Beck.
Chair, if I can just add.
Sorry, sure.
We really want to emphasize the issue of consequence management on the part of the boards of directors. And that's why we are taking this route, and we will follow through. Honorable Chair and honorable members, I really want to come back to the honorable members regarding the time frame of investigations. And when we were preparing to come here, I said, colleagues, let's expect a question around the date of the proclamation and where we are today. And that's where we're really indicating that most of the focus areas have been finalized. Now, to manage the effectiveness of the investigations, and as we go back and really prepare the dates of these referrals, it's going to be clear to the Honorable Committee that when we started with the investigations, when is it that we make referrals? Because as we always say, that we don't wait for the conclusion of the investigation and the writing of the report before we make referrals. So some of the dates of the referrals for disciplinary actions and criminal actions, you'll find that even though we started in 2019, some would have been made, earlier. So I want to really just assure the complexity and the documents missing are the ones amongst others that contribute to the length of the investigations. But when evidence is picked up in any particular year, 2020, 21, 22, and we will indicate all of those dates when we submit, that investigations focus areas would have been completed earlier and referrals made at that time. If up to now, it's really to make sure that we follow through with the referrals. So the principle I'm really putting forward is when we start with the investigation and we pick up, assuming we started in 2019 and we pick up evidence pointing to irregularities in 2020, we would have made the referrals then. And other focus areas continue. We pick up the evidence and would have made it then. So the length of the time, and we will also indicate, if we say complexities, what kind of complexities are we talking about? That has made us to be where we are today. And as we were preparing, and we do take it. And this is the point that we have made time and time again, and we are really working hard to ensure that we don't have instances of this nature where investigations are on our books for 5 years. Although actions would have been taken, but we really want to close the investigations and submit the reports. Thank you.
Thank you very much. Honorable Beck.
Chair, I want to just commend the structure of these engagements as we're having them now. In that vein, I'd like to dig into a particular issue. So I want to ask a couple of pointed questions, and with your indulgence, might do 1 or 2 follow-ups. We're seeing in the DRC at the moment that we can't use our Gripen fighter jets because Denel hasn't completed certification for the missiles it's developed. Has this missile development featured at all in your investigations? And more generally, has certification at Denel featured in your investigations? Separately, I'd like to understand from the presentation you've now given, and some of the amounts are staggering, in your estimation, how many of these matters that you've mentioned now is having material follow-through on the equipment available to our soldiers in Mozambique and the DRC? Thank you, Chair.
Thanks very much. Please go ahead with your answer.
Thank you, Chairperson. I think then the development and then the commissioning of those missiles that the honourable member spoke about, it's not part of our investigation. So I think the only matter that will have a ripple effect on the vehicles for SANDAF chairperson would be the who faced a contract, because all those variants that were going to be designed and manufactured by Denel were for SANDAF at the end of the day. And as already reported, out of those 264, only 21 were finalized, but not yet delivered to AMSCO. Thank you, Chair.
So that's the 8.1 billion over 10 years, right?
Yes, Chairperson.
That one.
That's one. That is
All
the
right.
one.
I think there were two questions. Didn't you referred to the grippins were not part of, I think that was that your second question?
I actually think the colleague has answered it, Chair.
Oh, sure,
I just
okay.
want to make sure that I've got the quantity of the problem down. So you've said more than 260 should have been delivered. 20 are being finalized but haven't been delivered. And the total cost for that is more than 8 billion rand. Is that right?
That's correct, Chairperson. I indicated that the 21, they've been built, completed. However, the AMSCO has not taken delivery of those based on then the conditions of the contract.
So just to be clear here, Chair, our soldiers do not have the equipment they need. None of it's been delivered. And it's because of Denel and corruption there.
That was a comment. That was a comment, right? So they don't need to respond.
They don't need to respond. Thank you so much for the information.
Thank you. Thank you. Honorable Atkinson.
Thank you very much, Chair. As I said earlier, I think a lot of us are sort of maybe mistakenly looking for rationality in these reports. You know, when we say, but surely why do you need external lawyers to do a white paper? Or how can you ask for legal services and you get almost nothing in return, and then when you go to the lawyer and the group CEO, they won't respond back to you. And when you look at contracts that have been done and there's been almost no follow-through. A lot of that happened, I think, probably around 2015, 2016, between 2014 and 2018, okay? So, I mean, to me, it's complete barefaced corruption and theft. So I looked up on the internet and it said here that Salaji, who was the head of Denel, was one of 3 Denel executives suspended in 2015 by the newly appointed board chair, Daniel Mancha. Mancha was one of the key role players that enabled the Gupta family members and their associate Salam Essa to capture Denel, according to the Judicial Commission of Inquiry into State Capture. The commission, led by Chief Justice Raymond Zondo, found that the Guptas used their influence to ensure that 2 Denel contracts worth hundreds of million rands were awarded to the Gupta-linked VR laser company in 2014 and 2015. So the point I'm trying to make is if we're trying to find rationality here, there is none, because it was actually just pure theft, and people were just grabbing whatever they could because they weren't worried about the future. They were just taking whatever they could for themselves at that time. I think what they didn't account for was years later now, the SIU getting in there and starting to investigate and starting to follow up with people. So all I can say is that I do hope that with that lawyer who basically ripped us off and ripped off Denel, that he gets referred to the lawyers' council so they can have him actually taken off. And also, as Honourable Beasley was saying earlier about the obligations of members of a board, I mean, this is actually criminal, basically, what they've done here, is that they've completely disregarded any of their responsibilities. So there are a whole lot of things here which are actually shocking and mind-blowing, but I don't think we can actually, as rational people, give it any other reason than it was just a period of complete theft within that organization during the period. And thank you to the SIU for basically trying to repair the damage that was done over that time. Thanks.
Thank you very much. We're about to go on break. I just have a very simple question. So I noticed in the beginning, the software, the Microsoft procurement, there is outsourced EOH and another company to get the Microsoft. Is that what really happened here? Because Microsoft has offices here in South Africa. Am I to understand it that way, that they were trying to procure Microsoft software from a third party?
That's the case. We're going to go into that presentation.
Okay, that's
Yes,
fine. So
yes.
that was just a question.
Yes, yes.
So the second one is relates to, it's a general question, because your referrals go to the NPA and not the Hawks. Isn't it a remnant of when the Scorpions used to be in the NPA, and that something needs to be corrected in the legislation? Because in previous hearings, it's clear that the process is you refer to the NPA, NPA refers to the Hawks, then it comes back up to the NPA, which is a longer process. I just want for clarity, if you can deal with that quickly, because it seems odd to me that we do things that way.
Correct, Chair. I think that's really the fundamental issue in the system. And we've identified that. And as part of really seeking to mitigate that risk, because it takes too long. And in our engagement with the NPA, that we have spent resources and time and money, investigators investigating an aspect, coming up with affidavits, which in our view depict a prima facie criminal case. NPA takes the affidavits because they've got a view that we're investigating, as they've said. I think in Parliament, I'm not sure if they've said in scope. I think they did, that our focus is on civil, civil outcomes, which we have said to them, we do not agree. Now, based on that, now they on-forward our affidavits to the Hawks for re-investigation. Money, efforts again. So that's where the fundamental issue is in the system. We have identified that, and we are really glad that and I'm possibly just mentioning it here, that it has also received attention by the council that the president appointed to advise on anti-corruption architecture, on how to change things fundamentally going forward. And they're really looking at it. They've consulted with us, they've consulted with Hawks and NPA. So, Chair, as we sit today, and that's why the number of cases that are outstanding that have been referred to NPA, that's why the number keeps going up. It's because there's this on-forwarding process to Hawks reinvestigate, go back to NPA, and so on. It is a real issue. But as I said, it's receiving attention.
So there are two issues that I recommend, TB, and we're going to go on break now. Two issues. One is that, I don't know if lacuna is the right word. The Scorpions used to be in the NPA. They are not. The Hampepe Commission removed them from the NPA back onto the SAPS. The law saying you must refer to the NPA then changed. It basically became irrelevant. That needs to be fixed in the legislation. We can't live with that sort of thing. And so we're going to make a note here, talk to the Justice Portfolio Committee and the Minister of Justice, fix that problem, because that's one thing. The second thing, we can discuss this at another time. We discussed this, we were sitting here, all of you. The issue is this. The cops have to say, I was at News Cafe with so-and-so and so-and-so, or at Cubana, or at wherever people meet to have socials, right, and talk. And so-and-so said this, and then compile a list of witnesses, interview those witnesses, take statements from them, etc., etc. We had the conversation here, and I even made the example that what was 800 pages becomes 8,000 pages. That, unfortunately, we can, again, have these conversations. Your investigations are not the same type of thing. You're not putting together a docket for a prosecutorial decision. That doesn't mean we don't fix the problem. We still need to fix the problem, but I don't want us to keep referring civil type files to the NPA. Those cases will get thrown out of court. That's just true, because we don't have a list of witnesses, no witness statements. We have got an investigation in the corporate sense over governance matters rather than. So I just want us to be cautious about how we characterize the thing in hearing, because it needs all of us to work together to fix the problem. Because Advocate Mutibi, we are as frustrated as you are with the fact that 10 years later, people are still sitting at fancy restaurants and buying expensive things. But thank you very much. I appreciate it. Members, it is now 20 past. Can we take a 10-minute break? I will speak to the SIU team about how to kind of just do the next phase so that we finish on time. We'll be back at past. Sorry. Is it 10 minutes too much for you, Honorable Member?
No, Xolo, Chair, sorry, there is one detail just the SIU must provide is on the contract 1161, what is it, Woofster? Yeah, on the 8.1 billion, you are indicating that some of it was utilized by Denel for Denel's things that were not part of the approved budget. Can we get that detail so that we are able to see how much was paid to the service provider in reality in relation to the 21 items produced versus what is expected? Thank you.
Thank you. Okay, it's 11:32 then, not 11:30. Thank you.
still on holiday.
No,
Like
I'm
you were
struggling.
working hard at home. I can see all the stuff that you did.
No, I'm struggling to be so used to. By now, I'll already be sitting in bed, like taking a break now. No,
Yes, relaxing a little bit.
an hour break.
Uh-huh.
It run about 1, take a 2-hour break.
Yeah, but what are you doing? Wait, do you clean house and stuff? Do you have,
No,
I told her I would help her not to come back, so I was
there is.
working.
I do have a helper.
And you must actually see me at home. I clean the floor with my feet, put cloths under my feet, and I do this. Yeah, it's exercise also for the circulation.
I'm not. Don't do that.
Now I'm looking for somebody again, but only for the.
Why? What happened to the other?
Yeah, she said she mustn't come back. She can't work properly and it's nonsense.
Oh, you got this?
Yes.
Yeah, you must have that thing.
But you know, how
Yes.
yeah. Now this is a problem.
What is it?
If this thing gets lost, but now I'm using this one can use what you call this thing? It's on this function.
Yeah, you showed me.
Yeah.
Showed me this one.
What?
Get fruits.
One more fruit?
But
Is
that's
no fruit?
standing.
Is it now no fruit?
But the fruit is still there.
Well, I think first help.
I'm so thirsty for something that I don't know. I went to go home. I couldn't relax.
One day.
Outside, it's so hot.
Yes, I know it's 29 degrees today.
I just felt it now. I said, yo,
Very hot.
so
When
I'm
was
gonna.
it last
And
week?
it's wet on the third floor. Our floor, there's no aircon.
I was going to come to you this
To
morning.
my office,
but
there's no
then-
aircon there.
No, but you don't complain. You're supposed to follow.
No, they
must
said, they said, they
cooler
said,
on.
no, they said public works must fix that, and it's costing 54 million.
Oh, so it's broken the whole
The
thingy.
whole floor. So imagine sitting there. So I'm thinking, as I go back there, because I've got so much things that I need to do. Just as I must tell, probably at home they
There's
they
this,
started.
she was saying you must do thank you letters after each meeting. Thank you. Thanks, and there's some of the things that we're supposed to follow up on and so on. So I said a few things to him, but now weekly meetings, I think you're going to be part of it also on a Thursday at 11 o'clock. Said the content advisor and the two researchers as well as one unit, because before the ministers will even come, it must be 3 weeks prior to it, so we list the things that needs to be done and so on and so forth. You will do the letter that the minister needs to concentrate on. She comes, like we said in the meetings, she's going to just, concentrate on the questions, the things that the committee needs. That's amongst some of the things. It gave me a lot of other things. I went there without the pen and paper, but I just jotted it down. He said to Chair, us involved in as a committee assistant, not just with the logistics and stuff. I said, well, maybe. But of course, I think there is a gap.
Yes, there's a big
biggest gap, I told you. So, dedicated person that you just do that you so they can, it's important that, and then
But you know what the nice thing about all this, I'm hoping
Hey, Nengwadi for one. Not just mine, by the way, another one. There's another, I bought it here in Cape Town, so we've got So it's I think I told you about it. It's this British journalist lived on the continent, I don't know, for 50 years. But he's written, he says Diamond's Golden War, okay, the making of South Africa. Yeah. But the book is essentially about Cecil John Rhodes, basically. But it's actually a great storyteller. You know, when you drive around Joburg, you were like, no, this is the building this guy was talking about.
You see his writing manifesting.
That's where
Well, I've always heard that it's a debate that we must have.
Yes.
And they don't meet at the same time.
Okay, let's wait for Advocate Motivi and then. Are you ready to proceed?
We are, Chair.
You are, okay. Over to you.
There's just one clarification.
Yes.
Around the value of the white paper.
Yes.
That my colleague would like to really clarify, and then we can move on. Thanks.
Thank you, Chairperson. I just wanted to place on record that it was not 9 million. The entity was appointed on a 0.47% contingency fee, and that actually equal to 6.5 million. But at the end, Denel negotiated it to 4.7 plus VAT. Thank you, Chair.
It's still a lot. I have to say it's still a lot.
No, thanks, Chair. Chair, I just want to understand this nature of this transaction. So, Chair, I'm going to ask this question like a very young man. So, Chair, Denel said to these people, come, go and raise for us a credit facility, ne? Obviously based on our credit standing and our financial obligation and so on and so on, ne? And then based on what you can borrow for us, we're going to give you a certain percentage of that, what you can borrow for us. That was the nature of the transaction.
That's correct, Chair.
No, thanks, Chair.
And I used to work for a bank, and the bank doesn't negotiate credit with third parties. But anyway, so it would be interesting. You negotiate with the client, not with a third party.
We are ready to proceed, Honorable Chair and Honorable
Yes, go
members, and Mr. Lekgetho will do the remainder part of the presentation. And then we will go into the general observations and systemic recommendations. Thank you.
Thank you, Honorable Chair and Honorable Member. I will be presenting on the Department of Defense. There are quite a number of proclamations that we are dealing on the Department of Defense. In terms of the first one is the one that look at Microsoft license. And in terms of the Microsoft license, there are 3 contracts which was entered by the Department of Defense. The first one was entered in 2016, where the value was 120 million. Then the second one was entered in 2017, the value was 131 million. Then the third one was 2018, and the value was 257. So going to the first one, Department of Defense approached EOH that they must provide them with the Microsoft Ware licenses, and of which they did provide them. And in terms of the process followed, the department did not follow the procurement process in terms of acquiring or appointing the EOH. And in terms of the value for money, the license were not used. The time when the department requested this license, Defense had already had other licenses of which it was really not necessary for them to procure the license that they procured at the time. So that's what happened. Coming to the second one in 2017, while they still have the 2016 licenses, they procured another one in 2017 with EOH, of which also they did not follow any competitive process, and still some of those licenses were never used. And on the 2017 one, they were also under delivery from EOH, whereby they didn't deliver all the licenses that they were supposed to deliver. That's why if you can see that we recovered 41.6 million from them, because we went through and identified how many licenses were delivered, and we found that the license to the value of 41.6 million were not delivered. So we confronted EOH, then they agreed to it that they will pay the money. They signed an acknowledgement of debt, and the money was paid. Then the 2018 Microsoft license, while they still have the 2016 and the 2017 and even other license that they had before, they went again to procure another license, software licenses, Microsoft with Soft One, of which on that one also, they did not follow the procurement process, and there was no provision for the budget for those licenses, and some of them were never used. So that's the process around the issue of the Microsoft license that has happened. Then in terms of the outcome, we have 14 referrals to the prosecuting authority. 41 referral to the prosecuting authority in terms of the criminal activity that we have identified. Then there's three investigations which were closed, and the relevant value of matter in respect of which evidence was referred for civil litigation. We are in court in order to cancel the 3 contracts to the value of 467 million, and that's 23 matters that we have referred for disciplinary action. In terms of cash recovery, we have recovered so far that 46.2 million that EOH has paid back for those licenses that were never delivered. So that's the first one pertaining to the Microsoft license investigation. The second one relates to the PPE investigation. In terms of the PPE investigation, the defense procured the PPE during the state of disaster, of which this one was investigated through Proclamation R23 of 2020. So here we receive allegation that there was an irregular SCM process which was followed, and there was collusion that we have identified with the members of the adjudication committee. And on this investigation, we have finalized it. Then in terms of what we have found that there was excessive pricing which was charged to the defense in terms of this PPE which was procured. And we also found collusion between the member of SNDF and the service provider, where we can confirm today, Chair, that some of them were bought vehicles, some of them received money through cash sent. So there's a lot that happened in terms of the members that were involved in terms of adjudicating this contract. And we also found money laundering attempts which were made. And so there's also, we've done some financial analysis, and we are in the process of assisting the DPCI in terms of criminal matters so that the people that were involved are charged. In terms of the actual outcome, we have referred 33 criminal referrals to the National Prosecuting Authority and AFU, and we have also referred 11 matters for disciplinary action, and 2 matters were referred for administrative action, that is Competition Commission, relating to the price fixing which was done in terms of the PPE. In terms of potential, we are in the process of instituting a civil proceeding through special tribunal in order to set aside the contract value to the value of 273 million. And we're also instituting civil proceeding also through special tribunal in order to freeze a pension of a former SNDF official that was found guilty. The pension value is 1.5 million. And we also refer one SARS referral in respect of 5 suppliers and 135 beneficiaries. Some of the beneficiaries are those ones that were receiving the money through cash sent from the service provider. And there's also 6 referrals for administrative action that we're going to do to Competition Commission. Then again, under SNDF, there's another contract that we investigated which relates to the interferon alpha 2B Hebron drugs. Yeah, this one, Chair, it was mostly mentioned during the PPE that the defense went and procured the drugs from Cuba. So that allegation came to us. Then we investigated that allegation in order to see what procurement process was followed. And according to the allegation, they've procured 930 units of interferon alpha 2B Hebron viral drugs, and the defense paid approximately 217 million to Cuba. That was the allegation. But the purpose of the drugs was intended to be used as an immune booster to all the soldiers as they were working around to make sure that people are in their house. The Military Command Council of the SNDF, which is the highest decision-making body in the Department of Defense, approved the acquisition to the value of 217. That is, the price unit per each viral was $15.50, which amount to 257 rand per viral. The SIU was required to investigate the possible unlawful and improper conduct of all the officials that were involved. From our investigation, we found that South Africa and Cuba signed an agreement concerning defense cooperation. And the 2 parties, in terms of the cooperation, it said the parties should cooperate to exchange information on science and technology in specified defense-related field and exchange student lectures, training, exchange information, and so on. So that's the cooperation that has been signed. Then what happened is that we found that in terms of this cooperation, the defense used that cooperation agreement in order to procure this medicine from Cuba. The department, the whole procurement was signed and supplied on the on 28 April 2020. we found that the supplement of 10 agreement, which was signed after the acquisition of the interferon, was finalized. That is, we found that the agreement was signed after the delivery of the medicine, whereby the first consignment was already given to South Africa on the 26th of April 2020. And the first assignment was for 130 vials of interferon, which was delivered to the department, and the department paid 33.4 million. The second and third consignment of the interferon were also imported into the country, but were never paid for by the defense. The department did not procure the interferon from Cuba by means of a competitive bidding process. That's the finding. And the MCC exercised the power they did not have when they approved the procurement of the drugs. In the defense, Chair, in terms of the Section 8, the Secretary of Defense is the accounting officer. All the procurement needs to be signed by the accounting officer. But in this instance, the procurement was not signed by the accounting officer, and the interferons were not approved or registered by the South African Health and Product Regulatory Authority to be imported and used in the country when they brought it here. And the department did not have funds in its budget allocated for the acquisition of the interferons, and drugs were never used by the Department of Defense as it was intended. They were also returned to Cuba following the court order that was issued against the department on the application by SAPRA. That is, SAPRA looked at it, then SAPRA questioned the defense, and as a result, they decided to take back the medicine back to Cuba. Only 15 of the total interferons imported from Cuba were used. And the one that were used, 10 were used on a patient at the one military hospital, and 5 of them were used by SAPRA in order to do the testing so that they can see whether is it a medicine that can be used. The department did not recover the payments made to Cuba in respect of the interferons. Remember, they've paid, and as a result, they returned the medicine back to Cuba. The interferons were found not to be fit for purpose by SAPRA, and as such, payments that DOD made to Cuba was fruitless and wasteful expenditure. Then the SIU is in the process of preparing referrals to the Department of Defense in order to discipline the member that caused the irregular expenditure. Thus far, investigation did not reveal any evidence of criminal conduct on any member of defense or any other person. That is, we did follow the money, the analysis to see whether was there any money that was paid to any official of the defense. We didn't find anything. Then we are also in the process of preparing referrals to special tribunal so that we can set aside that April 2020 supplement 10 agreement, that is the interferon contract, and we want to recover the payments that was made to Techno Import on behalf of Cuba. The investigation is currently ongoing. However, the SIU has identified the following preliminary finding: that institution of civil proceeding, that we are in the process of going to court in order to cancel that contract to the value of 217, which was entered by the Department of Defense with Cuba, and also to institute a civil proceeding in order to recover the 33.4 million which was paid for that medicine, because the medicine was never used and it was found by SAPRA that it was not fit for purpose. And also making referrals for disciplinary action against 25 officials, and that process underway. And we'll also be making the systemic improvement recommendation on the systemic deficiency that we have identified. Then the last one is another contract another proclamation that we have received. And this one, we have received it last week, Friday. And currently we are in the process of planning so that we can able to know how we're going to execute the investigation. On this one, we are looking at inventory verification and continuous assessment verification in terms of that bit mentioned there. And also looking at the supply, delivery and installation and commissioning of asset management system. We're also gonna be looking at any improper or unlawful conduct by official or employee of the department or service provider. So we are looking at these events that took place between 1 January 2013 to the date of publication of the proclamation, which was the 24th of January 2025. So this is currently where we are in terms of this proclamation. In terms of general observation and system, thank you.
Apologies, Chair. I don't know if Honourable Chair is going to take the same approach, or can we proceed with the general observations? I think it would
do the
help.
general observations
It would
because
help, yeah.
they might answer some of the questions
I
the
see.
members
Yes,
have
yes.
or invite new questions.
Indeed. Thank you. Thank you. Honourable Chair, thank you very much for that. Chair, as we indicated, while we focus on specific irregularities in the, depending on what the allegations are saying, and you'd see in the presentations, in the format, we start with the allegations, status, and so on. But what we also do, because our mandate really is to also identify systemic issues, which really, in our view, should be attended to. Now, on the Denel side, and Chair, really without rehashing what the members would have already read, it really just to highlight some of the observations. You'll see there on the Denel side, the first observation is around the board. The board, which is the accounting authority. Of course, including the ex officio members. And the ex officio member would be the group executive and possibly the chief financial officer and so on. We are saying they failed in their fiduciary duties in handling the affairs of Denel. And when we ultimately proceed with the delinquency process, of course, depending on what they say in their reply, because we've given them the right of reply, we envisage that we will proceed with the process of the delinquency over and above holding them accountable in other areas. For contributing to the financial failures and the governance failures of Denel. And then we say in the accounting authority there, failed to implement the process to protect Denel against litigation. Of course, one of their fiduciary duties is to protect the interest of Denel. Failure to discipline, members. The issue around the financial statements, funds being committed for the projects that are kept in the general business account that is used for daily activities. That's really using funds for what they're not meant for. And when they negotiated these business contracts, ordinarily you would expect that in these contracts there's provisions relating to the movement of people or at least employees or protection from poaching and so on. They failed to include the restraint of trade provisions, which would at least have protected Denel from some of these companies, poaching their employees. We've observed generally that there's poor contract management, of course, which has contributed now to the failure to deliver these major projects. We indicate there this Hoof Easter and Chat contract. There's poor record management. Again, that part comes up. Like in other observations we've made, that generally in state institutions and government, we really need improvement on record management. And then poor security controls on intangible assets, which led to the misappropriation of the intellectual property that we have reported on. So just briefly, really, based on the above observations, we have made certain recommendations, and these are really just summaries thereof. Ring fencing of approved project, including the budget, so that they are not used for other purposes. The issue of the restraint of trade, when they negotiate the business contracts of this nature, they should really look at including restraint of trade and other provisions that are necessary. And then the issue around consequence management, we expect that they should really proceed and implement consequence management. On the compliance side, compliance with PFMA, which is really should be obvious, but in many instances is not complied with. Treasury regulations and approved policies, and then the record management policy. On the Department of Defense generally, we've moved on to the Department of Finance. Failure to implement consequence management regarding a number of our referrals. We've raised this with the Secretary of Defense, and we've also observed that there was a general pattern of non-compliance with accounting officers' instructions, which is really problematic. The last bullet point on this slide, we observed that officials there, including the accounting officer, the Secretary of Defense, there's a sort of practice to use private or personal Gmail accounts for communication, and that is an indicator, Chair, although not conclusive, that it shouldn't be a practice that business matters are really especially like in any other business, the limit of personal accounts in dealing with business matters. Right. The next one really it's again the point we've made on the Denel side, budget allocated to specific projects being used for other business purposes. Although we are aware that there are financial processes if you want to move budgets from one budget account to the other, but in this instance we found that there's poor management of those. Poor record management comes up again, and in terms of recommendations, we've really recommended immediate steps to enforce consequence management, and then of course ensuring that accounting officers' instructions are adhered to. The issue around information security risk, to develop really the framework and policy prohibiting the use of private email accounts for official business. Number 4, unauthorized expenditure and budget mismanagement. Here really we require them to take into account any national treasury provisions or any policies that would prevent diversion of funds. And then the issue around poor record management also comes up. On the risk and mitigation plans, Chair, I really want to indicate that some of those risks are those that invariably contributes to the delays in the investigations, like the unavailability of personnel, unavailability of records. My colleague indicated that we, even in some instances, have to go to those companies that are sort of implicated and then to get the documentation from them, which is not ideal. Of course, the one other one that I really want to indicate, the inability to obtain sufficient evidence to determine lawful or unlawful conduct. That's again due to availability of evidence. Right, on the payments, we have seen some payment from Denel, payment of the SIU fees, and of course we have submitted to them the progress reports so that they can see what is it that we are billing against. The outstanding amount is 35.4 million, really, and we will continue to make sure that there's really value in our outcomes, particularly on the recoveries, so that we recover more. And if you compare to what we have sort of invoiced with what we will ultimately bring in, it's really worth the while. Honorable Chair, that's our presentation. We really appreciate. Thank you.
Thank you very much. I wanted to ask a question regarding the Supreme Court of Appeal judgment, because I think there was somewhere where there was, I think there is litigation between Denel and the service provider, and the contract should be set aside. And this is a general question, because the litigation I'm referring to did not emanate from the SIU, but it emanated from this department.
Yes.
Short version is, I don't know if you know about it, but okay, but this is being streamed, so I must say what it is. A service provider was hired to provide wellness services to military veterans, and the department did not have funds to cover the cost of the contract. When they issued it, they already knew that they did not have that kind of money, and they now can't pay the service provider. They tried to cancel the contract, but the service provider had already done some work. And the Supreme Court of Appeal has come back to say that it is unlawful for a government entity under the PFMA to commit itself to a contract when it knows it does not have the budget or the appropriation or the funds allocated to cover the cost of that contract. And therefore that contract was set aside. However, the Supreme Court of Appeal also said it is not the fault of the service provider that the government did not make sufficient provision, financial provision for this contract. And therefore the Department of Defense, or Department of Military Veterans in this case, must pay them for the work that has already been done. And I'm just asking whether, you know, and you can deal with this later, you know, when you start answering the questions from members, but it's a very important judgment, because some of what happens here is that someone didn't follow procurement processes. The service provider may not be at fault, but the contract is being set aside. The service provider has incurred some cost. What happens in that case? What is the just thing to do? Because you also don't then want to kind of throw the baby out of the bathwater by punishing the service provider for something that isn't their fault. So there is like a general thing. If you can just reflect on that, Advocate Motibi, you don't need to deal with it now because it's a general question, but I'd like us to just litigate it. So that's the first thing I just want to raise. The second thing relating to these matters is instances where the service being provided out of an irregular contract is of such importance that if you cancel it, there is a significant impact on the provision of a critical service. And the instinct for all of us is to say, cancel it, cancel it, cancel it. But then you have to deal with like 15,000 people who don't have access to something for 6 months or whatever the case might be, right? So again, if you can make that part of our discussion later on when we wrap up, I'd appreciate that, because it's got an impact on how we interact with various government entities as we go along. Thank you very much. I will start with Honorable Beck this time, Honorable Mente, so that I'm fair. It can, yeah, it's just in time. Unless you wanted to give it a pass for now, because you've just walked in. But if you can follow the same format, I want to apologize to you, Honorable Beasley, for last time. I wanted to say that when you suggest that MPs be arrested for votes, there might be nobody who wants to come to Parliament as an MP thereafter, in your earlier comment. But over to you, sir. Thank you.
Thanks, Chair. I stand by that comment. I think they should be arrested and look at the voting records. So in terms of a couple of things, firstly, you just noticed the risk of the SIU members, and I just think we need to acknowledge that you guys are heroes in this country. You're fighting against evil forces, and just to thank you for your incredible hard work that you're doing. And it's important that your members are protected, but just to thank you. Then in terms of the drugs contract, how do you set aside a contract with a foreign entity? And it'd be interesting to know were you dealing with Cuba as a state, or was there a company involved? And how do you set aside a contract that's got foreign involvement? And then one of your very earlier slides, you said the DoD is opposing the setting aside of the license one. Why would the DoD be doing that? I mean, it's nonsensical. You guys have done a finding, and now the DoD are arguing against that. And then also, have you recommended that EOH be placed on the restricted database because they've signed an acknowledgement debt, they've paid 47 million. But I think if we can start getting these big companies, these private companies listed on the restricted database, I think it will have a huge impact. And then just lastly, the systemic recommendations, who are those being made to? You know, who's responsible for taking note of that? Thank you.
Thanks, Chair. I will answer some of the question. The investigator will also come in here. The one for the jurisdiction contract, I will leave it for the members at the back. In terms of the EOH, from what I remember, but I will check here, I think we did recommend it for it to be blacklisted. So I think I'll check while we are busy here so that I can able to confirm it. And also the issue of why defense is defending this matter. I think also from our side, Chair, this was just really shocking that instead of the defense to be part of our application, they decided to defend the matter. We did engage the current Secretary of Defense, and she indicated that she was not even aware that they are defending this matter. When I spoke to her, she said she wants a briefing for us so that we can engage and they can able to take a position on this one because she's new into this role. It looked like they might able to consider. Thank you.
Thank you very much. Honorable. Oh, sorry. There's I thought that was incomplete.
Still other comments just before the colleagues come in. The question on who systemic recommendations sent to, they are sent to the accounting officers or the accounting authorities. And what we do is we then follow through with the implementation of those systemic recommendations. Now, on the contract itself with Cuba, I don't think we dealt with sort of Cuba as a government. Can you just indicate?
There's a third party techno import.
Yeah, that's right. Yeah, there's a third party involved. And now the issue around setting aside a contract involving a foreign company, we follow the same route. It's obviously, governed by the national law. So we will go to the special tribunal or high court, as the case may be, as we have done with other contracts, like at ESCOM, ABB being an international, and so on. Those contracts are then, governed by the national law, and then we get them set aside. Yeah. Which other points? Can you just check if you want to clarify anything? Chair, I think the main issue was around the jurisdiction of the cancellation of the contract, which I think I've assisted.
Can you just, before I move to Honorable Nontenja, can you just explain to the members, so what is the limitation on your ability to recover funds which are not in South Africa? Can you just explain the process? Because I want to work out what sort of other interventions the committee should make to facilitate recovery or to assist you in that sense.
No, thank you, Honorable Chair. I think it's mainly the jurisdiction issue, right? My colleague, Advocate Vanara, and he can come back to that point. he indicated earlier on that these are foreign legal jurisdictions, and therefore we wouldn't ordinarily be able to follow through. But as I said, there is a legal framework. There's a legal framework which regulates the pursuance of assets and fugitives that have gone outside of the country. Number one, we will obviously look at the contract provision. So the contract would regulate, how is it that we resolve the dispute, so to speak. Now, if assets have been carried outside of the country, there is a United Nations Convention Against Corruption that provides for processes to pursue assets and fugitives that have gone outside of the country. And Chair, that is really the work of the number one, if we know where the assets are. Because in various instances is that we may possibly take long in finding out where these assets are. If I use the IP as an example, we know where the assets are. So we would need to, in terms of the United Nations Convention, the MLA, the mutual legal assistance now kicks in. Now the custodian of the mutual legal assistance, the central authority in South Africa, is the Department of Justice. So that's the mutual legal assistance process. But now what I've indicated, that this will be a test case. We want to also explore whether there are avenues from a legal perspective, whether we can institute proceedings in that jurisdiction. That's what the legal team will advise on. Thank you.
All right, thank you very much. Honorable Nontenja, do you have any questions at this point?
No, Chair. My questions are to DOD and Denel.
Okay, directly. Thank you. Honorable Neil May.
Yes, thank you, and good afternoon to our colleagues and the SIU. Yes, no, Chairperson. Basically, I think what we've seen here at some stages, one becomes speechless because of the corruption and the manner in which we have not managed, from a governance point of view, to oversee this kind of looting that takes place. What my question is, where does the National Security Council and our national security come in? Because Denel, as a state-owned enterprise in the defense industry, holds sensitive and strategic intellectual property. Selling such assets compromise national security and gives other nations an advantage in military capabilities. So that is the one area that, and I'm glad we're going to be looking at, because having just done a little bit of research in the sense of looking at what you were saying, I would fully support you from an international point of view. There's Interpol, which is obviously our last resort, because knowing the challenges we've had with the UAE before, with the other cases, and that is the Mutual Legal Assistance Treaties, the MLATS, and that is where one would have to look at international relations. And what relationship have you got with international relations from government point of view? We could also look at what you were mentioning now, the World Intellectual Property Organization, WIPO, to pursue claims. It does take a long time, but I think, as you're saying, this is a test case. We need to look at that. From a South African point of view, this is also economic sabotage. And I think I looked up the definition of treason. One would look at, how would one look at that in a way, people were killed in the DRC, but one would rather look more for economic sabotage. This is a national disaster in the way we have allowed companies and individuals to plunder our sensitive information. Our IPs are are actually something that, as a government, we were very proud of, especially in the arms industry, where we would have been able to sustain ourselves and our own, military force. So I think on that side, I wanted to just check your relationship with international relations, because I think that is very important, coming down to how we are going to stop future processes that take our IPs out. And at the same time, the Security Council. How do we relate? How does this now become before the Security Council? Thank you.
Thank you. I don't know if you've got any comments in response to that.
Thank you, Honourable Chair. Thank you, Honourable Member. On the issue of the National Security Council, we haven't really checked whether this has served on their agenda. We can do so and really give a response. We haven't had from the National Security Council. We can explore that. And then relations with international relations. Indeed, there are platforms at which, as a country, we participate. For example, there is a network platform under the United Nations, and I mean we are a signatory to the United Nations Convention Against Corruption. Most of the provisions there we've really not really tested, Honourable Chair, and that is why I really refer to this as a test case, which we really have to pursue and see those provisions being implemented. The platform I'm referring to is a Globe E network. The Globe E network is under the UN. We are a member. UAE is a member, and a whole lot of other countries. And just to indicate that our counterparts in UAE, the UAE sort of anti-corruption authority, they've actually reached out to SIU for purposes of sort of international relations. They would like to, conclude an MOU with us. So as part of those engagements, we would like to bring all of those efforts to bear and contribute really to instances where we can drive those efforts towards adding value in recovering assets or even exchanging some of the information. So we are going to really ensure that all of those activities contribute to this positive results that we're looking at, using the Globe network, mutual legal assistance, and of course the international relations. As a department, we also interact with them. But we also want to use the legal process, whether direct access for civil litigation there is possible or not possible. Thank you.
All right. Thanks very much. I think, at another time, we'll just need to talk about how we close the loop, because usually it's through criminal investigations that the mutual legal assistance kind of would come. But here we're also talking, in addition, there's asset recovery and so on. So it's not so narrow. But I think let's just think about how we, in the next phase of our conversation in committee with NPA and others, maybe we ask for a presentation around those matters. Thank you. Honourable Bila.
Thank you so much, Honourable Chairperson. I think some of the questions that we are having will be answered on the 18th of February when the minister appear before this committee. Because really we are so worried. We entrusted people, put them in the department, in the SOEs, but they are not doing things according to the book. We don't know whether those people are not qualified enough to hold such a position that they are holding now. Because everything that is being done at DOD, whether at Denel, the result of that is that they are not done according to SCM processes. So if those people are not qualified enough or they are not responsible, Why can't we appoint people who will take this department and also the SOE from this mess that we are in now? Thank you so much.
Thank you so much. I think that's a comment. Thanks, Honorable Bila. Honorable Maduna.
No, thanks, Chair. No, Chair, I won't be long as well. I think, yeah, I've seen enough. No, Chair, I think, you see, if you look at the system of South African government, Chair, things like this should not be happening. Why I say so? Because if you look at the quality of our risk management processes, governance processes, as well as internal controls, there's always something that must pick up when something is not working. But you question yourself, if you reach this level, how did you arrive here? It means then it's not only these that are that are performing the wrongdoings that are wrong. Even those that are supposed to pick up when they are doing the wrong are also not doing their work. Perhaps we need to go back to that conversation that I think Honorable Madlala would have raised one day. That we need to speak about moral regeneration in public servants in general in South Africa. I think that's a problem that we have, because it tells you that, because if you are an accounting officer, for instance, you make a prepayment of whatever amount, you know that it's not allowed. And there are many, before you make a payment in an institutions, there are many processes or controls that you need to go through for you to be able to make that payment. So if all those people are allowing for these advance payments, overpayments, and so on, it means then we have a problem of morals as public servants. And we need to speak about the issue. How do we go to a program of moral regeneration? And perhaps even ourselves, Chair, as Parliament, I'm sorry that I will have to agree to this. I think Parliament as well should do more. Because if you look at DO, for instance, if you look at DOD, for the previous 2 financial years, they've been, actually for the previous 7 financial years, if I count, they've been on qualified audit outcomes. Now, Parliament should have long asked them, why are you not improving? They've been on qualified audit, you've been on qualified audit outcomes for so many years. Those are the questions that should have came from Parliament. Denel as well, if you look at Denel, they've been on disclaimer for close to 4 financial years. How do you continue to bail people who are on disclaimer? You need to bring these questions, because it was clear that that board or those people that are there are not going to turn around that institution. And you need to arrive at that level where you say, what decision must be made about these people, because they are not making any progress. You can't be on a disclaimer for 4 years and we continue to bail you out. Yes, we need Denel. But how do we then turn around Denel's government? These are the questions that I think it's very important that perhaps, Chair, we must ask ourselves. For the department, the DOD, in the previous financial year, they only achieved 3% of their targets. So that tells you the story in terms of what is happening there. So I thought that was that as a comment, Chair. And then perhaps, Chair, as I'm about to land, I just want to check. At what point does a person get to be declared as an enemy of the state? Because I think if you start to steal IP of the state, I mean, you are not a thief, but you are actively sabotaging the state. Because I think this is what this syndicate was doing in these entities. So I think it's a conversation that we need to have, Chair. I thank you.
In the US, it falls under espionage laws, and you're lucky to get under 25 years in prison if you do something like that. Basically, it's 25 years to life. Honorable Kupek. Oh, sorry. Did you want them to respond? Oh, okay.
Chair, just really to offer a view, we really do agree around, really a need for reform, particularly in the procurement space. But that need has been identified, and hence the Public Procurement Act. And perhaps between ourselves and the National Treasury, who are the custodian of the Public Procurement Act, really just to come and say and indicate to the honorable committee and honorable members, how is it that this space that is causing such bleed to government, the procurement space, how is it that it's going to be, reformed and measures put in place to mitigate the risks? But honorable members, it is true that when we now deal with collusion, it now goes to the integrity of the people that are in the system. Questions are raised in terms of how is it that we get there. And now processes like integrity checks, the integrity framework of government really needs to be looked at and see how best we can implement that. And between ourselves and the Department of Public Service and Administration and so on, we could then, have to come to the committee and say, how do we contribute to the improvement of the integrity space in the public service, including state-owned entities. Thank you.
Thank you very much. Honorable Kubeka.
Thank you, Chair. And greetings to the House, honorable members, and the team visiting us once again. Chair, as we sit here now, I'm seeing headlines in news outlets that 4 more SANDF members that are deployed in the DRC have died in a fight against the M23 rebels. Now, when you look at that, I've got a whole lot of notes that are written here, Chair, but I think I'll just comment, because I think directing those questions to the SIU team is once again somewhat unfair, because they are reporting on what they found. They are not the people to be blamed for what happened in these entities. Now, Chair, you given that you've got the Department of Defense, you've got Denel, you've got Arms Corps, and the capabilities that they have, from they're able to produce small and medium caliber ammunition for basically all types of weapons throughout South Africa and the African continent. They're able to produce air-to-air missiles. They're able to produce the Badger combat vehicles, helicopter maintenance systems, tactical missiles, mortar bombs, the Roy Falk, and a lot of other UAV, there's drones. South Africa should be supplying the rest of Africa with these arms and ammunition, and a whole lot of other strategic military equipment as well. Now, when you ask yourself, what is the reason for the deliberate breaking down of the Department of Defense and the deliberate breaking down of Denel, the deliberate breaking down of Arms Corps? What is behind that? Is our government afraid that once you prop up the Department of Defense, that there'll possibly be a coup d'etat? I don't know, this is just me thinking out loud, because I don't understand why you would want to compromise the security of our country. Why would you want to compromise our soldiers there in the DRC? You are sending them there with little arms, hardly any ammunition. They're running out of food. They're running out of simple things that any ordinary military should have. And this, what is happening in the DRC now, is going to undermine and show our weakness as a country to the whole of Africa and to the rest of the world. And if you look at our coastline is patrolled by one ship. The whole coastline of Southern Africa. And I think I get this from the other portfolio committee I sit in, which is transport. We went to see some of the vehicles that they have that side, and it's shocking. It's shocking. I think I'll rest here, Chair. Thank you.
No, thanks, Honorable Kubeka. So one of the reasons I felt the minister should come here early on in the year is also because the budgeting process follows soon after the budget votes and so on. So it's important that she comes here ahead of time because there's underfunding. But I'd also like to ask the members to read the attachment to the presentation by the Auditor General to this committee. So there was an accompanying report. I think there was, Secretary, yes. I'll just ask that she sends it again. Because the AG took a lot of effort to explain some of the systemic issues therein. So, for example, the leadership of the Defense Forces does not account as they should to the Defense Secretary, if you recall. This was raised as an issue. So the officers do their own thing. The AG can only speak to the Secretary of Defense. The Secretary of Defense has no authority over what the people in the armed forces do, and the system is essentially dysfunctional. Those are not questions that you can ask the SIU or the AG to answer. We need to ask the minister, what are you doing about this? I think the time to say I'm a new minister is gone. She has now had time to look at the same reports that we've looked at. She has been to see for herself within the department itself and the ministry, and she needs to come here and tell us specifically what she is doing about all of these systemic problems, which has the kind of outcome that we are now dealing with today, with 4 more of our fellow countrymen and women being killed again needlessly in another country. So the minister will come, but we will send supplementary questions to her after this hearing so that she can then provide those answers to us. Thank you. Honorable Plus. It's because you are a fighter. This is why.
Yeah, they must not start with me, Chair. You must tell them. No, look, Chair, I think just to start where you ended with the minister, I hope for a more comprehensive discussion, some of these things we can send to the minister ahead of time, so to tell her exactly what we want. But as part of that report, Chair, I think the minister must give us a report on this suicidal mission that's they've embarked on. Because part of now that we are reported 13 have been killed, but there's many more that are injured. So we might be receiving more reports during the week that more of these members are done. So we really need that comprehensive report. There must be accountability on that end. Look, Chair, I think with the SIU, the work is welcomed as always. I mean, there's been huge recoveries of certain amounts of monies that have come back. And also now the referrals, I mean, from the Microsoft, well, I don't know, I can't remember what it was, defense in total, that were 41 referrals. But with the PPs, there were also 33. I think there was another 30 with Denel alone and all of that. And Chair, you also spoke to this. And the NPA was here the other day with the Hawks and the SIU. But I couldn't get a sense in terms of the working relationship. So now you made a proposal of a systematic change or something that we must do in terms of clarifying this contradiction in terms of the law. Now, I couldn't catch out your sentiments, Chair, but I want you to assist me because I want us to, if we need to go to the Constitution or amend the law, have something that says that whatever cases that the SIU investigates, they must be given authority to criminally prosecute their cases. We're not saying they must replace the NPA, but we all say that whatever they investigate for efficiency, they must be given the powers to criminally prosecute. Because now we are crying here that 10 years of lapse, and we are not even getting the reports on these referrals. So now we must go and speak to the NPA to say the SIU referred, so what's the report on that? And they can't even get the reports on their referrals because the NPA does not report to them. So it's something, it's a lacuna in the system, as you will call it, Chair, that we really need to fix and get over. And then maybe just to steal something from Denel, there was.
So you also want to steal from Denel? You also want to join in?
No, not in that sense, Chair.
As a member of Scopa.
Because we've passed Denel, so I'm just taking something there. There was on the house contract. So there were 7 board members there that were referred for criminal proceedings. But I also saw that in those other guys that sold our IP, there were also 7 members. So I just want to find out, are these the same individuals? The 7 board members, are they the same ones who are accused of stealing our IP? If I can just get clarity on that. And then also, Chair, you can see that in this everywhere, I think this is also the minister must speak into this. There's a lot of sentiment or rob Peter to pay Paul vibes. You know, money is taken somewhere for something else and given somewhere. A contract, money for a particular contract is paid, but that money is not used to procure whatever is needed. Is used to pay salaries. So it's all over, both in Denel, in defense, and everywhere else. And those things are needed to be sorted. Last one, Chair, a direct question. SAPRA finds that the interferons are not fit for purpose. So in terms of the SIU, what then becomes the accountability measure on that? Because I think I got a sense that the procurement process were in line, everything was done accordingly, but now we've lost money because the interferons were not fit for purpose. So can someone be held accountable for that? Because now we've bought something we don't need and we lost money. And then we can't say because all processes were followed to procure that, therefore that's it. So I just want you to speak to that and then, yeah. Thank you very much, Chair.
Thank you very much. Honorable Blosser, just a quick one. I think we're going to discuss a plan, but I think at some point the Justice Minister needs to come and address certain specific issues because ultimately she must put the legislation through Parliament and we can support it. Thank you.
Okay, thank you, Chairperson. On the question around the HALS contract and IP, those people that we referred for criminal prosecution, they are not board members. Board members will be referred as part of then the entire contract on Hoofheister. So these were different individuals. For the HALS, it was a different set of officials, and then on the IP, it's different set of officials. So then the board will be, they are still part of then the right of reply that we are busy embarking on. Thanks, Chairperson.
Thank you very much. Honorable Mende.
Honorable Chair.
Oh, sorry.
On the SAPRA.
Oh,
question. Yeah.
Sorry.
Thank you, Honorable Chair. On the issue of SAPRA, indeed, they found that the medicine was not fit for purpose. There is accountability. The first one is the member that were responsible for procuring that medicine. We are in the process of making a disciplinary referrals against those members. And secondly, we are also in the process of instituting a civil litigation so that we can recover the fund that was paid for that medicine. And the other thing also, just to substantiate the earlier question, the Techno Import, it's a state agency in Cuba, and it deals with logistic. It's not a private company, so it's a state agency. Yeah.
Thank you very much. Honorable Mende.
Thank you very much, Chair. On the Denel, Chair, I'm foreseeing a similar pattern where service providers get business from the state, get money, and then when they are caught, they are quick to sign AUDs will pay it back. We agree with you. We are still as you and more shy. We will pay. Now, EOH has got a couple of contracts in the state. One of them is in the water, Department of Water, where also they agreed, they signed another agreement of debt at the Department of Water with SIU. Now, I think this is a third one. I was trying to check what is the third department. I think it's Johannesburg.
They
municipality.
have about 10 or 11 that they've either paid back or are paying back right
Yeah.
across the system.
Yes. Now, here is my problem when you investigate SIU and then you are picking up this pattern. What becomes your recommendations? Because now this pattern is carried over throughout the state. ABB is one of them, you mentioned them, and they are refusing to remove themselves. At ESCOM, they are embedded. We're still gonna deal with that. They just came back now through a new generator when we had told them no more. How do we fix this? What becomes your recommendation? EOH has got an ongoing agreement of debt with you at Water. Now has got an ongoing at Department of Defense. It can't be that these people are stealing and then only upon being approached by SIU to say, but you have stolen. You have taken that which did not belong to you and you didn't deliver services. So this is a deliberate act. They sign contracts, they don't deliver, they wait. Are we going to be caught? Are we going to reveal ourselves? Are we going to come forward? No, let's wait. If SIU catches us, we'll agree. If they don't, now it begs a question, how many other instances where we didn't catch them? So which means EOH has to be investigated right across on all contracts because they have become a number one suspect. What becomes your, besides what is prescribed as an allegation to you, what becomes a background check of this particular transaction and criminal activity that's happening here? Because SIU, you are the last hope when it comes to digging out all these criminal activities that are taking place within the state. This one of EOH is worrying me because how many other contracts are ongoing and where we didn't catch them, that means we do not know. Someone must reveal the facts or someone must complain. But they are so embedded into the system where they are corrupting the state, they are corrupt, the state is corrupt, officials and everyone. So I want to understand what will be your direction on this one. It can't be left at, no, we received this allegation, we dealt with this allegation, but there is a picture and a pattern which is clear, cut forward. They have an agenda with taking money off the state. Then number two is the similar to that one of the white paper, again on this Microsoft. This thing of Microsoft, I don't think it's very necessary when it comes to these departments getting this third part because each department must have an IT department. And these computers are bought with systems. So it's a matter of an IT specialist that comes to program your laptop, program the servers, then the whole network, then maintain. What's the situation there? We don't have IT components in our departments.
Honorable Member, even, but we've got a whole state information technology agents.
No, yeah, because I'm trying to get into SIU, when you investigate, what are the questions, what are the pertinent questions that you become to ask? Because there are things that shouldn't be a contract or an outsourced service. Similar to that thing of a white paper. This should not be outsourced because Denel is one big company that must have a powerful IT component because they are dealing with technology, advanced technology, and every information you can think of is there at Denel because these are the people that must protect us with everything. So when you receive this kind of an allegation, the first question should be, what does IT of Denel do if we are requiring this person? So that also, I want to understand what became a scope and everything. Then the last one is the reports that you have finalized, and you indicating that they are with the president. Can we get, I don't want your immediate response, let's just get a report on, we finalized this one on this particular time, we referred it to the president, this has been an action in terms of implementation of your recommendations, and wherever your recommendation was not accepted, there must be an indication of such, maybe there's contestation of your recommendation and all of that, because the reason why I'm saying this, it looks like we're going to have Chair go the same route of the PP where we had to take the matter to the Constitutional Court to make the recommendations of the PP compulsory until they are contested. Because what I'm picking up is that as far as the report goes to the president, but on implementation of the recommendations, there's very little we hear, except for the outcome of the SIU. As far as everything else that must follow, I can bet you now, seated here as members, how many members know that there had been consequences after you have handed the report, besides what you have done when you were handing over the report? Thank you, Chair.
Thank you very much. Please go ahead.
No, thank you very much, Honorable Chair and Honorable Mente. Just to start on that last comment, Chair, it is, again, another gap, lacuna, as Honorable Member said. And on this one, really, and Honorable Mr. Advocate Vanara, you can come in just to appraise the committee. We have prepared the SIU Act amendments. And as part of the SIU amendments is really to see where is it that we improve, SIU, business. This includes recommendations being binding. But that legislation, and we were assured by the Department of Justice that they will now process it through the legislation program. So the issue of recommendations being binding is a real issue. The presidency has really also, and they've come to present to SCOPA on the mechanism that they've put in place to monitor the recommendations of SIU in all other state institutions. We are really still to see that mechanism working and holding those who do not implement the recommendations to account. But the solution is in the legal, the amendment, alternatively the Constitutional Court, the same way as it went with the public protector. Honorable Mente, we really agree. We have observed a pattern with EOH contract. And I recall at some point, we engaged with the National Treasury because EOH actually wrote a letter, as the chair was indicating, that they've got contracts in sort of various other state institutions, and as you indicate, Honorable Mente, the letter that they have sent some time back, when we really started now uncovering all of this, they wrote to the National Treasury, almost seeking to, almost a bulk settlement, if I were to call it like that, settling all the contracts, and so on. But I'm not certain of what became of that process, because all of these contracts were now settled individually, right? So, Honorable Member, what we have done, of course, the process there is to really say, restrain, blacklist this company. And we have done that. We have just checked now. In the water affairs, we have processed their blacklisting. And the blacklisting process works, I'm sure the committee would be aware. We have to refer it to the company, the department that had appointed them, so that they process the blacklisting. But we do now involve National Treasury as well. So we have to make sure that that process is taken to its logical conclusion, which is to blacklist. In the Department of Defense area, we are also of the process of blacklisting. But in this event, I think one honorable member identified it, that why is it that Department of Defense is defending rather than being a co-applicant with us? Now, on that one, because there's this sort of differences of views, and we've now engaged with the Secretary of Defense that's now there, and now she seemed to have a different view than the previous. We probably will have a situation where they can also come as a co-applicant, depending on their view, and then process the blacklisting. Now, this is where now, from a pattern perspective, we have to inform National Treasury and indicate as government that this is a company that has really contracted across government, and these are instances where we have found it, wanting. Water affairs, in the defense now, and probably other departments, and indicate, like we did with Bain and the others as government, there is merit in restricting and blacklisting this company, and we will follow through. We will follow through on that. The issue around Microsoft, I think the Honorable Chair raised that issue earlier on. In instances, really not being an IT procurer, but it beats me that there should be this need for a middleman or middle person or middle company in procuring Microsoft. Because we are also of the view, because from the experience in dealing with the IT department, at least at SIU, and having dealt with CETA in many others, there is really no tangible business case to have a middle company to procure Microsoft, because you can go direct. You can go direct and procure Microsoft. I mean, for example, in SIU, we've now implemented, sort of the latest Microsoft 365, and we went direct to Microsoft. We didn't have a middle company having to do that. So, again, dealing with, we have indicated instances of collusion where you're dealing with, people who set up schemes such that they benefit them. We will always really find instances of this nature. We have to really dig and say, why is it that you needed a middle person? What was the business case, right? And in that instance, understand, because more often, the modus operandi of those who want to fleece money out of government is to create instances where there's middle people, so that that process is used for paybacks and all of that. And I'm just indicating it as a general modus operandi that we have observed. In this instance, there's really no merit in having had the middle person. Thank you.
Thank you very much. I'll come to you, Honorable Beck. I just want to say, I'm going to ask Honorable Mente, the Secretariat, to just find out about EOH, because if my memory serves me right, there was some kind of global arrangement reached between themselves and either the Zondo Commission or the Department of Justice, or both, because they were embroiled in the Zondo Commission matters, and they remember that their then new chief executive came to testify before the commission and essentially confirmed the matters under investigation and then said we will pay the money back, basically, out of the. So we must just find out what the specific resolution, if we need to write to the various entities, we will. But there is a story behind the settlements, because I remember watching the testimony that day, and the commission issued a statement. So there were a couple of companies that paid money back. They were one of them, and the commission issued a statement. But we'll provide a report to the committee. So I'm just going to ask the team to just dig into those matters and see also if there was a list of contracts that was appended to that commitment to refund. But there was something like that, where there was an amount of money that they undertook to pay back to the state. It's just a matter of detail, basically, so that we can then, continue with the rest of our decisions about what needs to be done. Is that to this? Because I want to go to Honorable Beck.
No, just a matter of detail, Chair. That if SIU can also give us, not only related to this, all the recommendation of the companies that are supposed to be blacklisted, so that when we meet National Treasury, we also get their perspective on what is happening, because we have now, I think this is a third company where we know for a fact there was a recommendation of blacklisting, but the company continues to have business and they're getting new contracts long term. We're not talking a contract of 2, 3, 6 months or a year. Long term plus maintenance and all of that. Let's please have that. Thank you.
Honorable Kubega. This is a follow-up to this one, eh? Okay.
Yes, thank you, Chair. On that one, when you go and find out about the same information you're looking for, Zondo Commission and all of that, could we also find out about VR Laser? What happened to them? Are they being prosecuted as well? Because if, given the grand scale corruption that was happening here, what's the story there? Because I think we need to figure out as well what's happening with the GCO of Denel at the time. What happened to him? That's Stephen Berger, the one who actually appointed VR Laser to come in, knowing full well that he shouldn't have appointed them. So can we find a link there and figure out what happened to that situation there? Thank you, Chair.
Are you worried that you don't drink and you might need a drink when that information becomes available? But that's your decision. Honorable Beck, finally. May I greet Honorable Esek. Welcome, sir, and all the best for the new year. Good to see you. Honorable Beck, you are last this time.
I think I'll forego the opportunity after all. Thank you, Chair.
All right. Thank you very much. No, members. We've got to conclude soon. But may I say, because there's just a few short slides left, right? I think it's about 4 or thereabouts, or not.
Chair, we've completed.
Oh, you've completed. Okay. No, that's fine. So, I wanted to say, so we're going to say, well, that being the case, Honorable Maduna, I'll be kind, because it's our first sitting.
Thanks, Chair. Chair, I just want to ask one straight question.
As you learned.
Yeah, is the advocate saying to us the department was defending its EOH? Is that what I'm hearing? Because I'm questioning myself if you are defending a service provider from being blacklisted, that's the money of the state again. So I just want to be sure that I'm hearing you correctly.
Yes, Chair. From a litigation perspective, that's what we said in the presentation. Normally, we would issue papers against the service provider to set the contract aside, and would expect the state institution, in this case the department, to be a core applicant with us. But in this case, they are a respondent. They are sort of defending. Yeah.
South Africa is alive with possibilities.
Honorable Chair, there's there's just two questions that you raised, which I want to
Yes, I was going to come to that. Yeah, please. Yeah.
offer some response. And my colleague, Advocate Vanara, can probably come in if he's got a view. I'm aware of the Supreme Court case that indicated that if governments should not really go out and procure for services that they didn't budget for, just in brief, which we agree with as well. But for purposes of recoveries, and that is why at the end of the civil litigation process, where a contract is set aside, there is this exercise, legal exercise called, determination of what is just and equitable, in terms of, what the companies should pay back and so on, whether they keep profits and they, and then the court ultimately awards an order that takes into account what the company has delivered and so on. So it's sort of not totally prejudiced, because in a sense, as the court indicates, well, not in all instances that they are honest or what sort of clean. In many instances, the state officials would have colluded with the companies, but where we find that collusion, then there would be corruption, which is a criminal offense, and then in that instance, the court is likely to order that they don't even keep profits. They pay back all the monies. So it will really differ on facts and circumstances, but that usually is taken into account. Now, what happens where the services are critical? A typical example, Honorable Mente refers to ABB. There's a typical example, which we did, when we investigated at ESCOM, we returned a finding of, negative finding against ABB, cancel the contract like we would do. And ESCOM said, this is a critical service. We need ABB, right? So from our part, we've done our part, and we've returned the findings. Contract has to be set aside. That's why we even went to the special tribunal to set it aside. It is set aside, at least the then contract. It was set aside. But Treasury now allowed ESCOM to enter into some dispensation because it was a critical service at one of the power stations. Without ABB, seemingly that power station was not going to, without ABB products or services, that power station
It's about 6, actually.
Yeah, that's right. So yes, those are instances where, reminds me of some other service provider as well at CETA, who was sort of there for, forever. And then we pointed it out and said, no, but government cannot, whole life depend on this service provider. But, because we have let it develop to an instance where we are dependent on this, it becomes very difficult to undo. But it's not impossible. Thank you.
Thank you very much, Honorable Mente. One last comment.
Yeah, just before you come in, Chair. No, Honorable Advocate Mutibi, I think we need to have a session. Firstly, I would like, Chair, that the team of SIU, when the department is coming here, is here. Because I can already foresee them denying a whole lot of things and then saying, no, this was not a conversation. The conversation was about that and that and that. Now, we have an issue, Advocate, like the ESCOM issue, where you set aside the contract because the service provider agrees that we colluded, we stole money, we were wrong, and you say, but the level of corruption does not warrant us to let you go. It means we must cut ties with you. And then someone says, no, this is a critical service. A critical service, we just dealt with a sole service provider here, single what. A critical service that can be provided by another company does not mean that company must not go. Those are two different things. Single source and everything else, I don't believe in those things of single source. Advocate Vanara will know. Here in Parliament, we have dealt with these things of single sources, and it has been proven time and again that there is always another company doing the same thing. But because people have already developed a relationship of corruption, they then start to establish certain strategies that, no, let's make it look like we couldn't find anything. So in the Treasury, when there was the other chief procurement officer, the one who left.
Brown.
No, not solely.
Oh.
Solely came with a report that proved to us that in South Africa, in all the departmental needs in South Africa, it's proven that, and in terms of procurement, there's always an alternative company. So even with ESCOM, there's no such. To make it worse, it's an insult to say an international company is the best. Then till now we can't do anything. Even in Africa, we can't find anything. If we can't find anything in South Africa, we can't find anything in Africa, we must go and find it outside. So we should not allow that. But then my problem, advocate, is what becomes a tool to you to say, but we said this must not happen, and it's continuing. Therefore, if it continues, it defeats the whole purpose of your recommendations to everywhere else. If ESCOM brings ABB through the back door because there was an explosion, there's an emergency, and then it's not even laziness in terms of research to find another product. It's a matter of embedded corruption. We know where we can get a quick kickback. We have our friends. Therefore, if we offer them a contract, we're going to be compensated properly. This has got all that statement written all over it. What becomes a tool to you to fight and assist the state to get itself out of this entanglement? Because at this point, we're not going to get out of it. Someone is going to come and say, EOH, we can't remove it. No, yeah, he will die. The whole state is going to collapse. Meantime, there's no such. And the worst part is that the conversation now on the domain is that Parliament must approve emergency budget for the soldiers and all of that and all of that. How do we do it and give it to a company that doesn't even have a mere legal office? It doesn't have IT. Even here in Parliament, we as members, we get laptops, we take them to Sally. Who's that guy? Sally. And then he and his team, they program. We don't get people from Microsoft or anyone coming to do our things here. You have a problem here, you take it to the IT office, they help you, they even do it, those things of remote free. Why? How are we going to approve a budget for the defense in this state? But when my most problem is that how do you fight with us? How do you help us as SIU to say, this is my recommendation. No one said this recommendation is set aside. Yet the implementation of it is contrary to what you are saying. Thank you.
Thank you very much, Honorable Mente. So let me intervene in this way. So one of the conversations I had while we were not in Parliament, I can't remember whether it was constituency or recess, was with the finance minister, to invite him to come and deal with the transversal issues in the committee. He has agreed to do so. What we're doing is we're just working through the budget calendar so that we also don't delay appropriations on main budget and budget tabling and that kind of thing. So it will be after budget. What we're trying to do is to get it to be before we go on recess now, after budget, but before we go on recess. He's otherwise said he will come to the committee and bring the DG with him and any other officials that are needed. So we just need to prepare a very specific issue. So it's both on their own audit issues, but also some of the transversal issues. I just want to make a couple of comments. I mean, the first one is that we talk here a lot about, why are people not being blacklisted and that kind of thing. There is also the longest lasting IT implementation project in the world called IFMS, which was approved in 2005. It's going to be 20 years this year. It's still not in place for 35 reasons, right? So what I'm trying to say is that unfortunately those things matter. We sit here and we say, why is so-and-so not being blacklisted? The reality is that if that system was in place, you can put somebody's ID number or personal number and their entire record comes up. And so for any hiring manager, it becomes easy. It's not necessary to then have a separate database somewhere, and because you end up with 600 databases and it just doesn't work. So I discuss those kind of matters with both the IFMS issue itself specifically, but also various transversal issues which affect right across. So we will have a wide-ranging conversation with different themes, SOCs, the government itself, local government, as well as these kind of issues. The last point I want to make is that we do need, as a committee, to take a view, because I know it's triggering when companies that have caused us great harm remain in the system. There are a few instances where there are several constraints. One, to take out and implement takes years. So even if you want to remove them tomorrow, you simply can't. They've got to stay. And then installing a new service provider also takes years. So there's a factor of time, then there's a factor of cost. I'm quite happy that we do these things, but one of the things I want us as a committee to do is that when we make decisions that have a cost implication, we then back it up by asking Parliament to fund the request and not leave it up to the entity to do it on their own at their own cost when it's a specific thing that we do. Alternatively, we have to find some other mechanism. One of the suppliers we raised, that was raised at ESCOM, Honorable Member, during oversight, you were there, was SAP. So as they do everything with SAP, HR, paying suppliers, banking, the whole bank shoot. So if they are to take it out and implement it, typically for an organization like that takes about 6 years to do it, to put it in. So all I'm saying is that on the same visit, we're talking about their financial problems. So if we are going to make a recommendation, my only plea is that in those instances, we then take responsibility and also say we're going to ask Parliament to appropriate additional money to do this. Because otherwise, it becomes a financial responsibility of that entity to do what we've asked them to do. So these are matters that I think in our stretch session we have to talk through so that we are also able to follow through on the things we ask for and not say do this and then they come back and they say we've got a negative on our income statement and then we keep quiet. So let's just do the thing comprehensively. Advocate Motibi, I want to thank you and your team. And also this length of presentations things is going to get there. We did well today. We were supposed to finish at 2. We are at 20 past with a break in between, so well done. Thank you very much. What I can commit to as a committee is that we're going to keep working with you, giving feedback to just making the presentations sing as a story. And we're doing the same thing with the Auditor General. We will be sending a general guide to departments and entities about how they put their presentations together as well, so that we can have this. I thought it was a good interaction, especially the format that we chose. I want to thank the members. None of you have fallen asleep, even though it's your first day. I am really impressed, but I do want to say Honorable Esek has been around the block a few times. He just arrived late to make sure that he doesn't fall asleep in the meeting. So but thank you very much, honorable members. We'll see each other tomorrow. am also told that there is lunch downstairs, salad and all of those kind of things.